Madam,
12 o'clock.
12 o'clock. Public.
Lordship, today the conducting counsel is unable to attend the
Which one?
item 5, item 6, and item 108. Kindly
5.
item 5, item 6,
Who
and
is not well?
he not well. Actually, he is attending his father's death anniversary today. My conducting counsel.
See, if you unblock, if you ask for adjournment, see the board is getting disturbed. That's the problem. We are adjusting the many matter to be listed, and if you seek adjournment, that's the big problem. Anyway, that's personal. No, but then we can't adjust according to your whims.
Next
It
week.
will go to November end. Press matter November end. Yes.
No.
So difficult to adjust the list, you know. Once you are seeking adjournment, it creates a lot of problem. So it has to go to the end of November. Yes.
Urgent bail matter, my lord.
Bail matter, no mentioning. You give it, we'll see.
I will pardon, my lord. Item 121. Lordship, it is a 376 case, and there is a stay order continuing since last 1.5 years. And I am
You are for informant.
I am for the informant. Lordship, can it be taken up as a last case?
I'll take it up today.
121.
Let us.
Yes. And now
CRL MC number 521 of 2024. CRL MC 521 of 2024. Though IA has been disposed of by your lordship court, but the matter was, even though enlisted prior to 2 months, it could not reach, the matter could not reach, my lord.
I'll just see what happened with that. Yes.
521.
Yes, 521. Yes, next.
Pardon, Your Lordship. I'm mentioning 4 matters, Your Lordship, that covers with my Lord's judgment. Akshay Kumar Naik versus Srimati Swarup Subhadarshini.
You tell me, what do you want?
I want for listing of that matter, my Lord.
No, these are quashing matters.
Quashing of the cognizance of 138 proceeding, my Lord. I am for the OP2. More than 55 lakhs.
You are the complainant.
No, I am the, yes, my lord, I am the complainant before the learned court.
Oh, give the numbers, we'll see. Huh? Give the number, we'll see. Yes.
Give
all the numbers, we'll see.
My lord, grateful.
482 application, my lords. This was specifically adjourned by your lordship to 7th of August, my lords. Now it is, let's say, any date your lordship pleases, my lords.
Take it, just see what can be done. I'm not assuring you, but we'll see. Yes, yes.
Item 1.
1.
Vigilance matter.
Vigilance matter.
POCSO.
Item 2.
May I please, your lordship?
Yes.
Your lordship, this is with respect to, I'm appearing on behalf of the petitioner, challenging the proceedings under section 138 of the Negotiable Instrument Act.
You are the accused.
Your lordship, I'm the accused.
Yes.
Pending before the learned subdivisional magistrate Balasore. Your lordship, in this present matter, the check that was bounced was issued for accounting purposes only and not for clearance purposes or any kind of security deposit, which can be clearly visible via Annexure 1, the distributorship agreement, in which...
Yes. Yes.
Your lordship, in which, if you could just see the security check clause, it has been clearly mentioned that we have received the check bearing number 84277275
Good faith.
in good faith for accounting purposes only and not for clearing purposes. Your lordship, we received a mail from the opposite party stating that 8 lakh odd figures were pending on us, and before giving us a opportunity of being heard, they issued the check, it got bounced, and they initiated...
The same check number.
Yes, your lordship, the same check number. And it has been accepted by the opposite party in their pleadings as well.
Where have you said that in your reply to the notice, statutory notice? Show me.
Yes, your lordship.
Notice was given to you?
Your lordship, the notice was received on 22 September 2021 via Annexure 4.
Yes, your reply. Yes, your reply at page 22. Where have you said that?
Yes, your lordship, our reply was in the copy of the mail, your lordship.
Land candidate check leaf bearing number so and so in good faith as security. Well, this is that again, this is your defense.
Yes, your lordship.
Yes.
Your lordship, we are praying that the amount that was levied on us, even if your lordship could see paragraph number 9, it has been clearly stated that we as petitioner or accused, we were subjected to a certain amount of discount and they were supposed to remit us some amount back. And when their personnel came to our office to check if we were in certain, we were supposed to give certain amount of money to the opposite party, even their men agreed that it was not us on which it was not us who were supposed to pay them back. It was them who were supposed to remit a certain amount of
See,
money
all
back
these
to
things,
us.
madam, all these things are your defense, basically.
Yes, your lordship.
You can take those defense. How can the complaint can be quashed? But I'm only issuing notice because you argued very well.
Yes, your lordship.
Okay, I'm just issuing notice. Issue notice to the opposite party, returnable within 1 week, file the process fee, let us see.
Much obliged, your
But
lordship.
you don't have a good case, but you argued very well.
Much
That-
obliged, your lordship.
Yes.
Item 3.
Pardon me, Lord. I was in the lead spot.
Which one you? Yes, yes.
Mr. Maharaj is not there, vigilance matter.
Mr. Maharana is not there, I'm passing it over. Huh? Let him come. Let him.
Second half have some issue.
Huh?
Second half have already.
Let us see, let
Yes,
him come.
madam.
He may ask for adjournment for you. Yes. Three. Huh?
From 18 to
In fact, he has some personal difficulty. Therefore, he was asking for adjournment. Beyond 18th, he want the listing
In your lordship.
because his sister is not well or something.
Any day suits your lordship.
After 18th, देखिए दे दो. Wait, the date will be communicated.
madam.
Yes, okay. Yes.
I just request 23rd or 24th. 24th will
We'll see in what way. Yes. 3.
item 3, final report submitted.
May.
Final
I've
report.
got instruction.
Mail.
Final report.
Mail.
I don't. You are seeking for quashing of proceeding.
Proceeding.
Petitioner is seeking quashing of the entire criminal prosecution initiated against him. Initiated against him. Meanwhile, the police have investigated the case and filed a final report. Final report. The OIC Hon'Ble, yes, has submitted a report and a furnished instruction dated 10/9/2024 24 that
IO has submitted FF as a final report.
IO
pass.
has the final
Report pass.
report being the FIR is false. Hence, nothing survives in the matter. It's dismissed. Yes.
Item 4.
Well, item 4 on behalf of Mr. SP Das, I am submitting this
Yes.
application. Well, the petitioner has filed this application for quash the proceeding on the basis of a compromise, my lord. And
What is the offense?
offense, my lord, 341, 323, 354, 354A, 10 POCSO Act, my lord.
Yes.
Well, the petitioner is the secretary of the Sudharagro search to home, and when the informant stay at that home and she tried to fled away, at that time the petitioner opposed to her, so the affair has been lost.
You bring them, let us
My lord,
bring them.
my lord.
Bring them, we'll see
Okay, ma'am.
what can be done. Yes. The counsel for the petitioner submits that the parties have settled the dispute. Accordingly, he wants to file certain documents. Leave the matter after 1 week. Yes.
Item 7.
Seven?
Only pass over.
Pass over.
Item 8.
7 vigilance.
Pass over. 8.
8.
Yes.
I pray for pass over.
Yes. 9.
Item 9.
Pass over.
Item 10.
Nobody is coming to the court. What is the problem? 10. Display is there.
Item 10.
20B2C, questioning of criminal proceeding, my lord.
Huh?
20B2C, my lord, questioning of criminal proceeding. NDPS.
Item 9 double pass over, my lord.
Pass over, I have done. Pass over. 10. Nobody is there. 10 also pass over.
11.
Pass over.
12.
Happening. 2 o'clock, everybody will come.
Good check.
Well,
Yes.
my lord, that is the rejection of discharge itself.
Discharge petition.
On 35/23, it was rejected.
Pass over.
13.
Can you pass over? You don't.
Pass over.
14.
So,
See, service. Just see. Then issue notice to the opposite party.
14 of private.
15. Pass over.
15.
Between the parties has been settled and they are coming to court. Just pass over.
What is the offense?
Offense is
294, 426, 355, 506. The
And
counter
lordship,
case,
yeah,
your lordship was-
case counter case.
Yes,
Earlier
sir,
lordship
counter
has
case, counter
quashed
case.
the
1 minute. He's saying something. Yes.
Case and counter case. The counter case, your lordship was this one.
yes.
12 o'clock. 12 o'clock.
Yes.
Yes.
16.
Yes. Yes.
My lord, item 16, I am on the VC, my lord.
Yes, yes. Tell me.
My lord, my learned senior, Mr. Suryanarayan Biswal is some personal difficulty, so this matter may be taken over
No,
any
I will
other.
not adjourn like this. If everybody will seek adjournment, then why should I lease the matters like this?
Actually,
Only passing it over. You pass over, otherwise I'll dismiss.
my lord, my
No,
lord.
nothing doing. Everybody in the
Actually,
morning,
I'm-
everybody is coming and mentioning, I lease so many matters, you will ask for adjournment.
No,
And
my
the
this is the
entire
first,
board is disturbed because of you.
no, my lord, this is the
Pass
first
it
case.
over, pass it over, pass it over. I'll just give a pass over, thereafter I'll start the case.
My lord, please, actually, file has been misplaced in our chamber, so I am
Whatever.
on.
Whatever,
My-
I don't know. I don't know. I am just giving pass over, thereafter I'll start dismissing all the matters. After
No,
that.
day after tomorrow, my lord. My lord, day
No,
after tomorrow.
nothing doing, nothing doing. Yes. What is this? In the morning, hundreds of lawyers are coming and mentioning. I'm adjusting my board like this and everybody is asking for adjournment. This is completely unfair. How
My
can
lord,
we adjust our board like this?
My lord, kindly this matter may be
You
taken.
don't want, why are you getting it listed?
My lord, kindly this matter take over day after tomorrow.
Next time. All pass over. You bring your file, whatever you want.
For question of FIR, my lord.
Yes.
Offense under section 420, 294, 506 by 34 miles.
Yes.
IPC. FIR is in the 2022, my lord. Last
Yes.
occasion, this honorable court direction given to take instruction regarding investigation of silence to 2 years, not submitting any final report or charge sheet. my lord.
The FIR was registered somewhere in 2022.
22, my lord.
22.
What is happening?
Actually, I have asked for the saying that due to the claimant himself who was outside, we asked him and then some portion of the CD only they have provided me. Where they have said after that they have taken the 116 statements, only one except the informant, other is saying the opposite to the claim.
Then file a final form.
Yes.
If nothing is
Yes.
made out, why are you,
Yes.
why this man will keep on suffering
Yes.
and get definite instruction? I'm listing it on Friday,
Not
Monday,
on
Tuesday. Land counsel for the petitioner submits that despite the fact that the FIR was registered on 3/12/2022, the investigation has not been completed as yet. The state council submits that the police has taken appropriate step for completion of the investigation. Statement of the witnesses have been recorded under 161 CRPC. Hence, he seeks 2 days time to get definite instruction regarding the status of the on Tuesday.
Interim order to continue.
Interim order to continue. If nothing is made out to file, it's a
Yes,
final
yes.
form and we'll close it. Yes.
only that part of that CD only is submitted where they.
Yes.
18 May, please, your lordship.
Yes.
Order against NPW, the petitioner before your lordship, NPW on the approach of
Issued
the
on one.
issued on first annexed 148 punch, your
petitioner-
lordship,
Oh,
20th.
yes,
5th
I am doing it. Petitioner is agreed by the order dated 21/3/2020.
No, that is 25 of 2020.
20.
20th of May 2020. On the next page, your lordship.
Wait, there is a-
Warrant was issued.
Yes.
Yes.
20th
But
of May
what
2020.
my submission before, sir, but in the meantime, during that period, the on 29th, 5th anticipatory bail was allowed in favor of
So
the
what do you
petitioner.
want? I'll cancel it, go and appear.
Yes,
That's
okay.
what I'm saying.
That-
Yes.
that is-
Directing to release the petitioner on bail.
Agreed by the order dated 20/5/2020, whereby the NBW has been issued against the petitioner for his non-appearance. The counsel for the petitioner submits that prior to the issuance of NBW, he has been granted anticipatory bail.
Prior to nine, just after,
And
on
after-
29th.
After the date
29th May of 2020.
submits that on 29/5/2020, the anticipatory bail has been granted by this court, huh?
Yes, ma'am.
This court. This court. In view of the aforementioned, the NBW issued against the petitioner by order dated 20/5/2020 is set aside, subject to the petitioner appearing before the court on or before 30th of May and seek remedy available to him under law, and subject to the payment of cost of 500 to be paid to the bar association.
Local bar association.
Yeah, High Court.
Here, yes,
Yes, allowed. Next.
obliged.
Lord, item 19, be kindly 2 weeks time.
See, madam, this is very unfair.
My lord,
See, how difficult it is for the court, do you understand?
due to illness.
I am
it's-
adjusting the board so difficultly. And you people are, every day you people are mentioning, list the matter. Once matters are listed and you want adjournment.
On behalf of Bharat Jali.
And after 12 o'clock, I am free. Because all the matters are adjourned. And what at which cost? At the cost of many people, those who are in the custody and all, their matters cannot be heard. This is completely unfair.
Due to illness, seniors are not present in this.
I don't know. Everybody has some problem or the other. What is this matter is about? Washing.
Release of the gold, actually, he is saying that 150 grams of the gold has been stolen, but
This is at the request of land counsel for the petitioner, release the matter in December.
20.
December first week, huh? अभी सबको December first week दो जो adjournment मांगा. Yes.
20.
This is very-
Arrange also, I will take up this matter after 2 weeks because some possible cases.
How will you? I don't understand this. I am just passing it over. After lunch, I'll start dismissing all the matters. Definitely, I'll do that. Then only you people will realize what kind of pressure the courts are having. You can't come in a sweet will and ask, lease the matter and thereafter adjourn the matter. What is this? You just see 50 memos.
My
If-
lord, show the plan that the matter was listed.
No, you give 50 memos, we adjust the board like that. At the cost of many matters which was the urgent matter which need attention. And once it is listed, you come and ask for adjournment.
And these are the face matters.
These are first matters. Then I'll dismiss it, we'll see, pass it over. Get ready, after lunch I'll dismiss it. And if it is so urgent, then you get it restored subsequently. Yes, next.
But herein I've challenged the cognizance order dated 7/10/2003, which has been lodged against the present petitioner and his mother for offences under section 341, 323, 506, 294 minutes.
Yeah.
In the in another CRLMC whose reference I've given Milots were pleased to issue notice and grant stay Milots. The facts of the case are such: the informant is the Amino who measures the land on behalf of the Tahsildar Milots. While he was on his official duty, he has stated the same in the FIR also. He was measuring another plot of land which belonged to the present petitioner and his mother for fun. It is written in the FIR.
For fun.
For fun. He was measuring when the present petitioner and his mother opposed him. How dare you enter our plot of land and start measuring it without any official sanction? Which is why the mother had filed a CLMC before my lords, in which my lords have been pleased to grant stay and issue notice. This is her son, my lords.
Let us see the charge sheet.
Charge sheet submitted.
What is the allegation? Yes.
At page
Yes.
page 37, my lords.
37.
My lords.
Okay. Just see, read it. No, you come to page 19.
19, my lords.
19. During the course of the report, we did the complaint from so, we haven't report from so, that the investigation of the case completed from the case is made out to the yes.
38, 39 is my FIR and charge sheet, my lords. That I had filed against that particular person.
Cognizance has been taken.
Cognizance has been taken, my lords.
What is the
294.
material against you?
There's no material against me, my lords. Even in the
Yes,
statement.
what do you say? Yes, sir.
My lord, specific allegation against the petition.
Read out.
My lord.
He has illegally entered upon my land, my lords. And he's measuring that plot of land.
What are the allegation against you? You tell me that.
My lord.
Don't say that what allegation you made against them.
My lord.
What are the allegation against you?
I have also instituted an FIR and counter.
That may be different story. That may be your defense.
My lords, may see page 12, the FIR of the present informant.
Yes. Against you.
Against me, my lords. I am Jeevan Jyoti Mohanty, working as surveyor Sakhi Gopal Tehsil. Today, as per order passed by Tahsildar, I reached village for demarcation. I reached that place around 4 p.m. due to heavy rain. Within 5 o'clock, I finished the measurement work. My lord has it. Then I found
a friend of mine
who asked me to measure his place in fun. This is the language of the surveyor, my lords.
Okay.
After a long time, I felt happy to meet my friend and I measured his place. At that time, one Debashish Patri, present petitioner, my lords, and Annapurna Patri, his mother, started scolding me by putting torchlight in my face. Annapurna Patri removed the mask from my face and misbehaved with me and pushed me, abused, scolded with filthy language. These are all omnibus allegations.
Along with her, Debashish
It is called him and applied criminal force. There is nothing what he has done, applied criminal force. Made false allegations saying.
What is this?
My lord, specific allegation against the
Right,
petition.
but
And some
in official work, you do it for fun.
He's written that
you
in
go
the
and take the measuring tape and started measuring the plot of someone else.
Let the custody. Obtain the custody after custody.
This is absolutely. How can you are the, how can you go to somebody's place and start measuring? And they got scared, it seems. They prevented.
Yes, the villagers.
CD, okay. CD called for. Where is that mother's petition number?
Mother's petition number.
They has already been granted.
Yes, my lord. CLMC
that
number.
They will suffice for you also.
Let me grant in this matter also.
So why? That stay will suffice, obviously. Investigation is going on.
Nothing
The charge sheet
prevents,
has been filed. Yeah, that.
nothing prevents them from.
That's right, but ability to be split. What are you
We
talking?
do
When
not.
that matter is listed?
That.
When that matter is listed?
I'll
Issue notice to opposite party. Issue notice to opposite party number 2. It's shown to accept notice and which first date. And then conservative petitioner submit that the co-accused, who is the mother of the present petitioner, has also approached this court by filing
CRMC number 1219 of 2024.
and notice has been issued in the said matter, and stay of the proceeding has been granted. Granted. List the matter along with the so and so after 1 week. Yes.
Plus, my grant stay in the matter.
After 1 week. No. That stay is there. Yes.
22.
Great.
Yes. 22.
Passing of rejection, my lord. Discharge petition.
Yes. Nobody there again.
That's already been framed, my lord.
Pass over, huh? Yes.
23. Only pass over.
Pass over.
24.
Here in this case, your lordship, this is the petitioner is aggrieved due to passing of an order, your lordship, in a date, my lord, it is a case on section 138 of NIR. On the date of hearing, cross-examination of the complainant, your lordship.
You are the accused. You are the accused.
I am the accused in the court below, my lord. I am petitioner before your lordship. My lord, what has happened? The date was fixed to 2/5/24.
Yes.
On that date, the conducting counsel, who was suffering from urine infection as well as high fever and was receiving treatment, he filed the junior advocate, the conducting junior advocate, he filed the medical documents as well as a time petition praying for an adjournment. The learned trial court, your lordship, at page 15, your lordship may kindly see that on a bona fide ground when the time was prayed, and the learned court below trial court imposed 5,000 cost with regard to taking of that time.
Are you agreed by the 5,000 cost or
my lord, what the learned trial court has further done, your lordship, the further party is very, your lordship, that part has agreed me, and on the next date, your lordship, on 20th June 2024, the evidence of the complainant PW1 was discharged.
It's closed.
Closed. My lord,
one opportunity I will give you.
Yes, your lordship, I will cross-examine PW1, and with regard to your lordship, imposition of cost. I humbly pray your lordship.
I'll put further cost.
Further.
Because 138 matter.
My lord, 138 matter, ground not, it is not the ground that.
My learned friend, suppressing not a single day that fine was costly. But my lord, can see this order.
Madam, see, he is the accused.
Yes.
He need to cross-examine the
witness. Yes.
Let him do so. And so far as the cost part is concerned, I am not going to enter.
Date,
so ask adjournment, then cost will be imposed. What do you want?
My lord, I may be given an opportunity to cross-examine. I will not take any kind of adjournment. And
one minute, I have made up my mind.
May I please? My lord, the complainant is residing at Singapore, and he's come for only this cross-examination from Singapore to India, and he comes 2 to 3 times for cross-examination, but due to deliberately delay the process.
You are in Singapore. You are in Singapore.
My lord. Yes, my lord.
Okay, then through VC.
VC is allowed, but
no, your address is in Tulsipur.
He is residing at Singapore, and the cause of action arises at Cuttack.
VC has been allowed, your lordship. VC has been allowed.
Okay. That petition is agreed by the order dated 2/5/2024, and the subsequent order dated.
Subsequent order, your lordship, dated 20th June 2024.
20th June 2024, whereby the petitioner's right to cross-examine the complainant has been closed. On 2/5/2024, the petitioner has asked for adjournment, and moved an application. The said application for adjournment was turned down with a cost of rupees 5,000 imposed on him to be paid to the complainant. Then consider the complainant opposite party submits that his client is residing in Singapore. That's the reason the petitioner is trying to harass him by calling for cross-examinations repeatedly. At this stage, the counsel for the petitioner also submits that he would cross-examine the complainant of the opposite party in the video conferencing mode if one opportunity is granted to him. One opportunity is granted to him. I feel it. Being the accused in the case under 138 Act has the indefensible right to defend himself. Therefore, one opportunity shall be granted to the petitioner for cross-examining the complainant. Therefore, the trial court is directed to summon the complainant on a fixed date, and opportunity shall be given to the petitioner to cross-examine the witness on that day. Without entertaining the prayer of adjournment, if at all, to be made by either party. However, I am not inclined to interfere in the cost imposed by the court below on the petitioner. Accordingly, the petition is allowed. The trial court is directed to fix a date for cross-examining the complainant, and the petitioner may cross-examine the complainant on the date fixed through video conferencing mode. With this observation, the petition is dismissed.
May I pray one thing? Ma'am?
Yes.
Further cross-examining may be allowed with cost, madam.
Again,
That
All 5,000 are
5,000
already 5,000. He agreed by that also. Yes.
My
next.
lord,
It's all right.
take one
You are in
speaking, just
Singapore.
summary trial
the
case.
video
My lord,
conference-
since
had it been
2020,
the inconvenience of the client to have no contact.
It's all right.
deliberately, my
It's all right now. Yes. Next.
25.
Yes.
My lord, questioning of criminal proceeding on the ground of compromise, my lord. The petitioner is the father of the principal accused. The principal accused case already quashed by valid CLMC number 18428/2026.
Sorry?
The petitioner is the father of the principal accused, my lord.
Yes.
The principal's accused case already quashed by CLMC number 184.
Where is that? You have not filed, except FIR, you have not filed anything.
My lord, the order copy is not uploaded, my lord.
Not uploaded. Yes, yes. By this court.
No. In 2016, my lord.
16 matter uploaded is not uploaded.
No.
Right? See? Certificate copy, you get the certificate copy.
Kindly tag with that matter.
Huh?
Kindly tag with the matter.
No. You have not filed anything. Charge sheet has been filed.
Yes, madam.
You accept FIR, you have not filed anything. You want quashing of the entire proceeding. You withdraw it and file proper petition.
Kindly take
With
note.
document.
Next week I will call you.
No. Right on. The petitioner is seeking quashing of the entire criminal prosecution arising out of Adoba PS case number 18 of 2011. Except the copy of FIR, nothing has been filed in this case, in this petition. Counsel for the state submits that the charge sheet has already been filed.
No,
Huh?
no, that instruction is not here, madam.
Charge sheet has not been filed.
As per the instruction, charge sheet filed, madam.
Charge sheet filed.
The case
Then
of
counsel for the petitioner submits that charge sheet has been filed. Charge sheet has
2011 matter.
Huh?
It's a matter of 2011, madam.
Charge sheet has been filed. This is a matter pertaining to the year 2000. The FIR is registered in the year 2011. Since the petition has been filed without enclosing any document whatsoever, I am not inclined to entertain this petition. Therefore, the same is dismissed. with the liberty to the petitioner to file a fresh petition with all necessary documents. With this observation, the petition is dismissed. Yes.
26.
But I made a BC, my lord. The offense
Yes.
under section 302, 201, 498 IPC, my lord.
CD is there?
CD, first one, first.
Fresh case CD called for. Yes. Next.
27.
Item 27, the petition already acquitted.
Acquitted. Land counsel for the petitioner submits that the petitioner has already been acquitted from the case. Hence, this petition will become infructuous, disposed of. Yes.
28.
Yes, your lords. Here is the case, madam. B2C of NDPS admin.
Recovery?
Madam?
Recovery how much?
Yeah, 150 kg.
150 kg.
He's the
Custody? Custody since?
His justice has already filed, madam.
Custody since?
Custody 29/1/24. 29/1/24.
Charge sheet filed when?
Charge sheet has been filed. Madam, the FIR laws in
Charge sheet filed when?
The final PR is 13/12/2013.
13?
12/2013 मसीहा FIR हिला
You are absconding.
Yes, ma'am.
Absconding. Right.
Old man.
I'm old man. No. He's not sole owner of the property. I am not going to give you bail because you have been absconding. There is a case of 2013. Charge sheet was filed in year 2013, and you have been absconding for about 10 years.
Sorry, madam. I am not absconding. I am in the home. I am working my village work. But the police are not being arrested.
Yes,
The
petitioner is accused in FIR number so. And after investigation, charge sheet is filed in the year 2013, showing the petitioner to be absconded. So, subsequently, after the issuance of NBW, the petitioner is apprehended, and he moved an application for grant of bail, which has been rejected by the trial court on 29/1/2024. In this present case, the recovery of the how much? What is the recovery?
150
recovery of 150 kg of contra ganja is contraband ganja is alleged, and therefore I am not inclined to entertain the bail plea of the petitioner. Hence, the same is dismissed at this stage. Yes. Next. 29. Yes. 29.
Petition has been in custody since 9/9/2023, my lord.
9/9/23.
2023, my lord.
Yes.
Offense under section 363, 366, 3762 and 3763 of IPC and 6 of the POCSO Act, my lord.
Yes.
Last occasion,
What happened in this case, my lord? 3763, my lord. Today morning, I contacted the IO. IO served the notice on the victim, my lord, today.
Mr. Raghunath, land counsel for the petitioner state submits that today he has got the instruction that the IO has served
notice
the prosecutrix in the case, hence leaves the matter out. Yes.
30.
In custody since 22/10/23.
22/10/23. Yes.
This case under sections 376(3) and section 4 of POCSO.
Service notice?
Yes, my lord, yes.
Anybody appeared?
Nobody has appeared. In this case, my lord, incident took place 1.5 years back.
Through the IO.
Yes, he has. It was sufficient. Through IO sufficient. I have.
23/8/2024, my lord.
Yes.
Annexure 3, my lord, is statement under section 164.
Read it. Read, Mr. Raghunath.
ଗତ 1.5 ବର୍ଷ ହେବ ମୁଁ ଗୋଟେ ଦିନ ପାଣି ଆଣିବା ପାଇଁ ପାଇପ୍ ପାଖକୁ ଯାଇଥିଲି। ସେହି ସମୟରେ ଆମ ଗାଁର ଶଙ୍କର ପାଇକ ପିଟିସନ ମୋତେ ଦାଣ୍ଡରୁ ଟାଣିକି ଜଙ୍ଗଲ ଭିତରକୁ ନେଇଗଲା ଓ ମୋ ଶରୀରକୁ ଛୁଇଁ ମୋ ସହିତ ଦୁଷ୍କର୍ମ ରଖିଲା। ମୋ ସହିତ ଜୋର ଜବରଦସ୍ତି ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା ଏବଂ ମୋତେ ଧମକ ଦେଇ କହିଲା କି ଏହି ଘଟଣା ବିଷୟରେ କାହାକୁ ଜଣେ ନ ଜଣେ।
You are not in relationship.
15 years age.
Only 1.5 years back. Only once I have taken her.
Once is enough.
Yes, and
minor.
Apart from that,
yes.
she asked about a single incident.
and she refused to examine by the doctors.
Okay. Long gap kara.
Long gap
Yes,
संगे
what,
कौन?
what,
Why?
any other evidence you will not even 1 year, not even 1 year.
1.5 वर्ष पूरा है क्या इंसिडेंट का को क्या ऐसे
let the witness be examined. Right
That victim exam.
Victim be examined. Right now. The
medical examination she refused to
I write
examine.
that petitioner is accused in so and so so. Then comes for the petitioner submits that although under 164 CRPC specific allegations are made by against the petitioner by the victim. However, the
Why is only
the victim has
only
refused
22
to
years
join medical examination. Refused to join medical examination. I perused the statement of the victim recorded under section 164 CRPC. She has made a specific allegation against the petitioner that the petitioner was dragged into the jungle and she was ravished. In view of the specific allegation made against the petitioner and the fact that the victim was 15 years of age, I am not. And I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea after the examination of the victim girl. Keeping in view the fact that the petitioner is in custody since 22/10/2023, the trial court is directed to record the statement of the victim girl, giving preference over all the formal witnesses. With this observation, the petition is disposed of. Next.
31 and
Yes. Yes, sir.
Target for them within 2 months, month or
3 months.
month or 2.
3 months. Yes, next.
Petitioner is in custody since 1/5/2024. Initially, FIR has been registered under section 498, 302, 304B by 34 IPC and 4 of the DPS matter. But in the meantime, charge sheet has been submitted under section 306, 302 deleted, my lord.
Yes.
And cause of death.
You are the husband. You are
my
the
lord,
husband.
my lord.
You tell me what are the allegations?
Allegation, my lord.
Charge sheet. Where is the charge sheet? Yes, yes, Mr. Lagoda.
Charge sheet I have not received, though I have received the CD, my lord.
Charge sheet, my lord, 25/5/2024.
13/5/2024 up to 13/5/2024 I have received the CD. Now
See, 20 when the charge sheet filed?
25/5/2024.
25/5/2024.
24.
You go to trial court. Right on. Petitioner is agreed by the order dated 22/3/2024, whereby his bail plea has been rejected. The initial FIR was registered against the petitioner for offence under section 498A, 302, 34, 304B, 34 IPC, read with section 4 of DP Act. However, after investigation, charge sheet has been filed on 25/5/2024, dropping the allegation of dropping the allegation of 302 IPC. Since the bail plea of the petitioner was rejected during the investigation and subsequently the charge sheet has been filed, therefore, on the changing circumstances, the petitioner shall approach the court of first instance by renewing the bail plea. At this stage, I am not inclined. However, the liberty is granted to the petitioner to renew the bail plea before the court below. With this observation, petition is disposed of. Next. 32.
May I please, your lordship, the last occasion it was directed to file the surrender certificate. Also, my lord, the deposition copy of the victim may be sought to State Council, my lord.
You have surrendered?
Yes, my lord.
Surrender? Certificate you have filed?
Yes, my lord, I have already filed this.
See, what are the allegations, let us see.
My lord, deposition, in the deposition.
Victim has already been examined, my lord.
Victim
Yes,
examined.
after the copy, my lord.
Put the
So then you, victim, when victim was examined?
certificate.
Victim examined, my lord, on 6th August 2024.
Then you go to trial court. Land counsel, the land counsel or the petitioner submits that after the interim bail, his client has already surrendered, filed this surrender certificate.
My lord,
his
victim-
bail plea was rejected on 19/3/2000.
My lord, victim already stated.
Not
she-
supported.
She
Not
does
supported.
not she doesn't want to proceed the case. She has
73
not
says
kept
better.
any sexual relationship.
What she says?
My lord, the
Stated,
certificate.
I am the victim in this case. The informant in this case is my mother. I know the accused Chandrapatra, who is present in the court today. The occurrence took place 7 months back. On that day, there was a quarrel between our family members and family members of the accused. So my mother lodged the FIR at PS. I have given the statement before the magistrate on section 164 CRPC. This is the said statement exhibit 1, and there are my signatures. I was medically examined. This is my signature in medical paper. This is my signature seizure list. At this stage, PP declared her hostile manner.
Then she entered. Petition is accused in the coercion also. After interim bail, he has already surrendered and filed the surrender certificate. Meanwhile, on what is the date? Meanwhile,
On 6th August.
6th August 2024, the victim girl has been examined. She, in her statement, has wriggled out resigned from her earlier statement under 164 CRPC. Therefore, the prosecution has declared her hostile. She, in her statement, has stated that there was a quarrel between the family of the petitioner and her family. Therefore, the mother of therefore her mother has registered the case against the petitioner. However, she has stated that I have stated that before the magistrate I had made the statement under section 164 CRPC regarding her to the fact that the petitioner is in custody since 1/3/2024, and the fact that the victim girl has not supported the prosecution case when she was examined by the examined in the court. The petitioner is bail. Accordingly, bail is granted, and with all these conditions, he will serve. Yes, bail granted.
Hello,
Yes.
And for the petitioner one,
33. Yes.
He surrender certificate submitted before this court, my lord.
Yes, sir.
Yesterday he surrendered, my lord.
Yesterday he surrendered. The pursuant to the interim bail, the petitioner after expiry of the interim bail, he has surrendered and filed the surrender certificate before this court, which is taken on record. Yes. Next, main matter.
Your Lordship, I'm pressing in this case, my lord, FIR is at annexure 9, my lord.
What is the stage? What is the stage?
Charge sheet has been submitted.
When?
On 31/3/2024, my lord.
Then you go to trial court. By the order dated 24/1/2024, the bail plea of the petitioner has been rejected. At that point in time, the investigation was going on. Subsequently, on
31/3/2024, my lord.
31/3/2024, charge sheet has been filed in the present case. In view of the changing circumstances, petitioner should approach the court of first instance by renewing his bail plea. Therefore, I am not inclined to entertain the bail plea. The present petitioner will face, however, liberty is granted to the petitioner to renew his bail plea before the trial.
I think after submission of charge sheet, bail application.
Huh?
After submission of charge sheet, bail application rejected.
No. Before that.
Before that,
I have seen it.
24/1/2024.
No,
it is 24/1/2024.
24/1/2024.
Yes. Next.
My appearance, my lord, I am appearing for the son of the deceased, your lordship, in this case.
Son of
Deceased son, your lordship. My appearance,
recording
your lord. I have my affidavit is also in flat K, your lordship.
Your presence will be recorded. I
Yes,
am not granting anything. Yes, 34.
May I please, your lordship? The petitioner is in custody. Both the petitioners are in custody, my lord. One is 24/2/2024, and another was arrested subsequently. That was petitioners were in custody since 24/2/2024 for the alleged commission of offense under section 376D 294 506 34.
My lord, earlier, my lord, charge sheet rejected, my lord.
In the meantime, the
15th
victim has been
24.
examined. He did not support the case of prosecution, and
due to some disturbance.
Charge sheet sometime and subsequent, my lord. The date of rejection.
The victim has not supported, then what?
Your victim copy definitely official.
Read it out, read it out. Which part?
Para 2.
Yes, para 2.
On that the accused person has consumed liquor and had not met and hot word of exchange with me. So I lodged the FIR against the accused person in the police station. Your lordship may kindly see he was turned hostile and accordingly in
1
the
minute, let me read it. Police has not taken anything from you.
already copy receipt is with me.
Yes. Madam.
But, petition D, my lord.
But
Petition D, there are two cases, my lord. Two persons.
Both the cases, but the victim herself says that nothing has happened. What to do? Right on. Petitioner is accused separately though. The petitioner is accused in FIR number so. The allegation against the petitioner is such so. The victim girl, who is 27 years of age, has been examined as PW1. She, in her examination chief, has inter alia stated agenda 2, 3, and 4. 2, 3, and 4 paragraphs. The prosecution has declared the witness to be hostile. Since the victim girl has turned hostile, and subjected to cross-examination by the prosecutor, nothing could be elucidated from her statement. Therefore, and other witnesses have also been examined as the PW 2 and PW 3. And perusal of the evidence of those witnesses also reveals that none of them have supported the prosecution. And the petitioner is in custody since 24 to 2024. In view of the period of custody and the fact that the victim and other witnesses have not supported the prosecution when they were examined in the court, I'm inclined to enlarge the petition on bail. Enlarge. Yes, both the matters. Same. Another.
Two persons.
Yes.
35.
I am permitted to move this application on behalf of Mr. Samal.
Yes.
May I please? My lord, petitioner is in custody since the month of December 2023, my lord.
Date is now
18/12/23, my lord.
18/12/23. Okay.
For commission of offences under sections 308 of 374 of IPC, 14(1) of
Charge sheet filed.
Yes, my lord.
Yes.
Charge sheet filed in the month of March this year, my lord. And 75, 79 of
Siddhi I have not received, my lord. But in fact, he is released on interim
bail, and I have surrendered in time.
Yes.
And the surrender certificate filed. And
now, when the charge sheet filed, date, give me the date.
Charge sheet filed on 14/2/24, my lord.
14/2/24. Thereafter, yes. Yes. What are the allegations? What are the allegations?
As per FIR, my lord, ମୋର 15 ବର୍ଷ ସାନ ପୁଅ ଖେଳୁଥିବା ସମୟରେ ପ୍ରବୀର ପଡ଼ା ପିଟିସନର ତାକୁ ଆର୍ଥିକ ପ୍ରଲୋଭନ ଦେଖାଇ ସର୍ଭିସ ସେଣ୍ଟରରେ ମୋର ପୁଅ କାମ କରିବା ପାଇଁ ଡାକି ନେଇଥିଲେ। ସାଧାରଣ ଗାଡ଼ି ଧୋଇବା କହି ବିନା ଏସିଡ୍ ନିରୋଧକ ବସ୍ତ୍ରରେ ଏସିଡ୍ ଗାଡ଼ି ସଫା କରାଇ ମରଣ ମୁହଁକୁ ଠେଲି ଦେଇଛନ୍ତି। ମୋର ପୁଅ ଏବେ ଜୀବନ ମରଣ ସହିତ ସଂଘର୍ଷ କରୁଅଛି, ଯାହାଦ୍ୱାରା ଗୁରୁତର ଭାବେ ଆଘାତପ୍ରାପ୍ତ ହୋଇ କଟକ ଏସି ମେଡିକାଲ ଭର୍ତ୍ତି ହୋଇଛି। ଡାକ୍ତର ପରାମର୍ଶ କ୍ରମେ ସୁସ୍ଥ ହେବା ପାଇଁ 10 ରୁ 15 ଲକ୍ଷ ଟଙ୍କା ଆବଶ୍ୟକ। My lord, injury report is required, my lord.
My lord, injury report is with me, my lord. The opinion is all injuries like B by L, forearm, BL, thigh, lower aspect of abdomen, and simple in nature.
164.
All these are with me, my lord. And the definition of child is, the child means a person who is not uh, above 14 years, my lord. And as per the charge sheet, the injured person is 15 above 15 years, my lord.
The last page of the rejection. Smriti Ranjan Janna has a sustained secondary degree deep burnt injury of a fatal body surface area of 15% while he was injured. Sitaram Samar has sustained secondary degree burnt injury, total body surface area 25%. The cause of injury is chemical burn injury.
Oh,
Further,
My lord, kindly have a glance to the injury report, my lord.
chemical bond.
15 years boy.
And he released an interim bail and never misused the liberty granted by
Right,
this.
that may be a ground for repeating the bail application. Second degree burn. Burn injuries are there.
164 statement also.
But all the injuries are simple in nature, and all the offences, my lord, punishable within 3 years, my lord.
That's right.
Allegation, sir.
You repeat your bail application there. Right.
With some observations,
Okay,
like
please,
that.
right now. Then comes but the petitioner submits that after the interim bail granted to him, he has already surrendered and filed the surrender certificate. He submits that
That also may be reflected that he has not misused the liberty.
he has further submitted that he has not misused the liberty, rather in time he has surrendered. On merit, he submits that the injuries sustained by the victim are simple in nature, and the victim is 15 years old.
Above
Therefore,
15.
he doesn't come under the definition of the child. Which definition you are reading?
No, section 2 of 2 Roman I.
2 Roman I of
Child labor protection, that
which act?
Child labor prohibition and regulation act
Child
86.
Labor Provision and Regulation Act. Regulation Act. In the present petition, except to the FIR, no other documents have been filed. It would be appropriate for the petitioner to urge all the points before the trial court on merits by renewing his bail plea. If he moves such application, the bail plea shall be decided on the basis of the documents form part of the charge sheet, and the same shall be decided
And on the injury report also.
within 15 days. Within 15 days of moving the application. With this observation, petition is disposed of. Yes, next. 36. Yes.
As per prisoner question, I have filed a vakalatnama.
You take so and so and files vakalatnama. This is a prisoner petitioner. Yes. Argue on merits.
Day after tomorrow, man.
Huh?
Day after tomorrow.
Not day after tomorrow. You argue what is this
Today,
matter?
today I have filing vakalatnama.
It's all right. I am passing it over. Read it. And except rejection order, there is nothing. Charge sheet has been filed. Yes, Mr.
Rejection on 23rd 4 2024 and CS file 16 4 2024. After that,
Yes.
16 4 2024. Charge sheet submitted.
26 2 and all. What is this stage now?
Charge sheet submitted, my lord. And our 160 statement is there. 17 years. ମୁଁ ଆଶିଷ ସେଠୀକୁ 7-8 ମାସରୁ ଚିହ୍ନିଛି। ମୁଁ ତାକୁ ଇନଷ୍ଟାଗ୍ରାମରେ ଭେଟ ହୋଇଥିଲି। ଆମର ଫୋନରେ କଥାବାର୍ତ୍ତା ହେଲା। ଆମେ ଦୁଇ ଜଣଙ୍କ ଭିତରେ ଭଲ ପାଇବା ବଢିଲା। ସେ 27 ଇୟର ଅଛି। ସେ ଅହମ୍ମଦାବାଦରେ ହୋଣ୍ଡା କମ୍ପାନୀରେ କାମ କରୁଅଛି। ଆମେ ପ୍ରଥମ ଥର ଏପ୍ରିଲ 2023ରେ ଦେଖା ହୋଇଥିଲୁ। ସେ ଅହମ୍ମଦାବାଦରୁ ଭୁବନେଶ୍ୱର ଆସିଥିଲା। ଆମେ ହୋଟେଲରେ ଯାଇକିରି ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲୁ। ସେ ବହୁତ ଥର ଭୁବନେଶ୍ୱର ଆସି ଆମ ଭିତରେ ବହୁତ ଥର ଶାରୀରିକ ସମ୍ପର୍କ ରହିଛି। ମୋର ଘରେ ଏକଥା ଜଣା ପଡ଼ିଲା। ତା ଘର ଲୋକ ଗାଳି ଦେଲେ। 15/1/2024ରେ ସକାଳ 7ଟାରେ ବାପା ମୋତେ ନିରାକାରପୁରର ବସ୍ ଷ୍ଟାଣ୍ଡରୁ ଛାଡ଼ିଲେ। bus stand chadile.
What is the age of this girl?
Girl age my lord is 17 years. At when
Boy
statement recorded.
24.
My lord.
Get the record. Get the record. Get the record. Because he has entered the appearance. Next week? Next week, huh? Next week. Next week. Yes.
37.
He is entitled to bail.
Apply.
May I please? Charge sheet submitted under section 376 2 and 417. Petitioner was arrested on 25 February 2024. Charge sheet submitted on 21st March 2024. Thereafter, the petitioner has moved bail application, which was rejected, madam.
Yes.
On 22nd April 2024. Your Lordship, kindly have a glance to page 10 of the FIR. At the intervening day, 2017 to 2019, the occurrence took place. There was a love affairs between the petitioner and the victim. And
what is the age of the victim?
24 years, ma'am.
24 years.
And
read 164.
And on the previous day of his marriage, this FIR is lost.
In 164, read it.
And that 2019, she has lost a FIR that ended in compromise. Victim has received 5 lakhs. That is also there in local.
Against this same
again,
victim.
for the self-same, he has.
Initially, FIR lodged, my lord. There was a
settlement.
Settlement.
And this petitioner has given 5 lakh.
Yes.
That is not there, but in fact, my lord,
Local
again, my lord, the petitioner committed the same thing, sexual intercourse with the victim. And when the victim asked to marry her, she did not, my lord, marry her and married somewhere else. For that,
No. There are
one day before
after
marriage.
Yes. 2019, there is no occurrence, madam. 2023, when my marriage fixed to another lady, previous day she lost the FIR and I was arrested subsequently. And in she has denied for medical examination. Page 20.
Then he is entitled. The petitioner is accused on allegation against the petitioner. Then comes for the petitioner submits that earlier in the year 2019.
19.
FIR number?
That that PLA case number page 14.
You give me the FIR number of 2019.
2019 FIR number during course of the trial.
No, this is no way. You have to assess in that way. At least I should write the number of FIR. Urgent to next week.
No, after lunch, madam. After lunch, I'll
pass it over.
Pass it.
You come with
Yes.
At least
After lunch, I'll provide the with a memo. I'll provide the
pass
PS.
it over. Yes, pass it over.
38.
Wrongly.
May I please, your lord?
10/10/2023, Lordship. 10/10/2023.
10/10/23. Recovery is 187 grams. Regard being had to the thief and custody is from 10/10 to 23. I am inclined to with all the conditions. Yes. What is that? Yes.
Item 40.
Lordship, case indicate bail Lordship.
I will not say anything. What will happen? I have granted bail. By you, it is done.
Lordship.
What will happen? Subsequently, let him pay. I am not taking note of this at all. I am just granting bail. With the condition, verification and all, then he'll come to you once again. Once again.
Bail
I will not write. If I'll write that, then I'll have to reject it.
No.
So I'm simply giving you relief.
Sometimes what happened, Lordship, while applying for bail application, there.
Again, he'll come to you. Don't worry. Yes.
Item number 40, my lord, it is a matter of 302 CD has not come.
CD hasn't come. 40.
Yeah.
Yes. Problem. 40 CD call for. Yes.
41. Lordship से केसटा मेंशन कर ले फिर गोटे केस एक्विटल भी हे जाईची अदरवाइज से काई लोक हरास करबा लॉर्डशिप आई में लॉर्डशिप
then 37 will come unnecessary. I have to reject it.
अच्छा
Did you follow what the problem is?
ना खैर इंडिकेशन कर देने एटा थिला पिटिशन
Then I have to reject it. Then okay, I'll record it and reject it.
Below
Then there will be a bar. What to do?
Below commercial quantity.
Commercial quantity, you can't keep on indulging in many cases.
Not many cases. Lordship, since 100 gram acquittals.
So therefore, since you are acquitted, the trial court will bound to because there is no case pending against you today. Why should you invite that unnecessary? I am granting you bail.
Lordship.
If you are already acquitted, you are bound to be released on bail. Why are you inviting? The FIR was initially registered for the offence punishable under section 450, 376, 302 and 34. Charge sheet has been filed on 3/7/24 for alleged offence under sections
450,
450,
452,
452,
302, 34.
302, 34. The offence under section 376 has been dropped in view of the changing circumstances and the fact that the earlier bail application was rejected during the investigation. Here, petitioner may renew his bail plea on the changing circumstances before the court of first instance. With this observation, the petition is disposed of.
Kindly glance. 376 is not made out against this present petitioner.
That is why it was dropped.
Again, 376
May not be, but this,
you can argue all these things because at the investigation stage the charges were very serious, therefore it was rejected. Now the charges are very charges are dropped.
I mean, arrest taken say ground, say offense.
So therefore you will be granted bail now. Trial court, yes, next. 42 withdraw.
No, madam.
Withdraw?
No, madam. I will see the order.
Huh?
I will see the order.
There is a memo, sir.
No, madam. Madam, I'm just explaining. I have filed the application.
Not to press.
Madam, just bear me for a moment. That's why innovative idea, alternate motive has been telltale. Madam, I am explaining. It's a case where the
Who has filed this memo?
Madam, just bear me for a moment. I am explaining this. I have filed the bail application and this honorable court is kind enough to adjourn the same for a particular purpose, for calling for the CD. During pendency of this ballot, another bail application has been filed before the honorable court, suppressing the fact that regarding pendency of the bail application and wherein bail has been granted. Madam, this is the order.
Bail has been granted.
Madam, see the order. And just to see that my power will be deleted so that I will not be in a position to give a clear picture before the court. This principle has been, this alternate process has been adopted. Madam, see the order. And one thing, madam, I take note, the London trial court during pendency of the bail application also entertained the bail application once again, rejected the same, for which he is able to file another application before the court. This is the order, madam.
This is very serious.
And the registry has also not pointed out this before the court. And today, things has been come. And only to see that I will not be in a position to give a picture before the court. I will be prevented.
But this has been done in your office.
No. Certainly not.
The memo is
last one. No, I have not filed, my lord.
Who is the counsel? Huh?
My lord, from the jail, if disengagement memo has been filed, perhaps just to see things will be do better in this manner.
When this matter was filed?
Well, first, madam, see the bail application.
This matter is pending since
4349. I filed it.
This is 4349.
Madam.
This is 7193.
Madam.
Subsequently,
a bail application was filed before the court below. But the trial court has also entertained without checking, and there also no certificate has been filed. And he has also entertained, rejected the same, for which he has a bail filed the bail application.
While the present bail application was pending, then the present bail application was filed on 5/1/2024. Numbered as 4349 of 2024. While this bail application was present before this court, it appears the accused has approached the trial court without disclosing the fact, without disclosing the pendency of the present bail application. The trial court appears to have rejected the prayer of blame. Thereafter, the petitioner approached this court by filing ABPL number 7193 of 2024. In the said application also, the fact that the present bail application is
pendency of bail application
pending before this court has not been disclosed. It appears the coordinate bench, oblivious of the fact that a oblivious of the fact that the same petitioner has already filed another petition, which is pending before this court, has allowed the bail plea by order dated 25/7/2024. At this stage, so as to camouflage the entire thing, the counsel for the petitioner moved a memo seeking withdrawal of the present petition.
Madam, may indicate the name of
Counsel for the petitioner, Mr. K.C. Behra,
who has been engaged through jail, because
who appears to have been engaged through the jail, has moved an application for seeking withdrawal of the present petition. It is surprised that neither the registry has pointed out the same, nor the counsel appearing for the petitioner in the present petition has pointed out the same. Rather, on the contrary, attempted to withdraw the petition. Let a report be sought from the registry by tomorrow. Lease the matter tomorrow. I'll recall this. I'll send it to the consent bench for recalling of the order.
And my lord, your lordship may call for a report from the district judge from the session court.
Yes, yes.
whether he
Trial
has
court
given
will
a certificate or not. Because he has suppressed that no bail application is pending before the High Court. Suppressing that he has filed a bail itself.
because circular has was. My friend is out. Circular has been issued by the registry to all concerned to check it all this is. That's and this certificate.
Let a report come from this court, then I'll send it. I'll recall the order and I can't recall because the coordinate bench is given. I'll along with the report, I'll send it to coordinate bench for recalling. I'll just thank you very much, Mr.
No.
Yes.
The petitioner filed separate petition for quashing of FIR. And the parties are present pursuant to your lordship.
No, this, where is the ticket?
Page 34. This is case and counter case. And
This
case number 44, your lordship was the
petition quashing of FIR. This is the other FIR, which is
Other FIR,
right. At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. There was a cross case filed by the petitioners against the opposite party number 2. The petitioners, the opposite party number 2, Babuna, 34. Opposite party number 2 had filed CRLMC number 723 of 2024 for quashing of the said FIR. While order dated 2/5/2024, this court has quashed the FIR registered against the opposite party number 2 by the at the instance of petitioner. It is relevant to reproduce the order passed in that case. In that case, while that is reproduced 2/8/2/5. At the instance of the next paragraph, at the instance of opposite party number 2, now this FIR number so they said against the petitioner. Parties have settled that dispute. They have filed an affidavit dated 11/9/2024. Inter alia stating that on the intervention of the village gentry, they have settled the dispute, and the opposite party number 2 is not interested to prosecute the petitioners anymore. The affidavit is written on the board. The petitioners and opposite party number petitioners, na?
Yes, sir.
Petitioners and opposite party number 2 are present in the court. being represented by their respective counsel and identified by them. They've also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken on the court. Regard being head to the fact that the parties have settled their dispute and the cross case has already been quashed by this court by the order dated 2/5/2000 क्या था 2/5/2024 while allowing CRLMC number 723 of 2024. I'm inclined to allow this petition. Accordingly, the so and consequential proceeding is quashed. Yes. All of them are present.
Yes, sir, all are present.
Sure. Let us see who are they. Shashi Malik.
Shashi Malik.
Okay. And Ramesh. Babu.
All.
Okay. Hello. Yes.
Item 100.
100 also. Settlement? Compromise. 100, yes. 100.
Ground of compromise, we are present and prior to this, also an update was filed.
Can you hear yourself?
Passing of FIR on the ground of compromise.
Yes. What is the allegation?
Under the case is that the younger daughter.
A charge sheet has been filed?
No, my lord.
Yes. What are the allegations?
Allegation of my lord 376.
376.
Yes.
What is the age of the?
My lord, the victim is a married girl. My lord, the sister of the victim with has a law relationship with the petitioner. She fled away with the petitioner. Out of anger, this case has been filed.
No, I didn't follow. Yes, sorry. Tell
My
me.
lord, the sister of the victim
Fled away with the petitioner.
With the petitioner.
So therefore, she filed the.
The case has been lodged by the victim, the elder sister, that the petitioner raped her.
False case.
That is
what they are saying now.
मतलब बाहागर हो जाइए से वर्तमान बाहागर सरलाणी पिटिशनर ଆଉ ସେ जो झियटी सान
younger sister they married
under annex 2 मंगला मंदिर रे बाहागर हो जाइए
right
तन केस
where is it girl
they are the parties
Lipina Naik Ramesh Naik
Rajesh Naik
so Rajesh Naik हाँ लिपिना नाइक वो तुम सेटल ही गला समाधान नहीं गला कौन समाधान होला हाँ राजेश बाहे गला भूणी सहित छोट भूणी सहित आपनकर किसी प्रॉब्लम नहीं पास कर दवा खत्म कर दवा केस right at the instance of opposite party number 2 the FIR number so and so came to be registered against the petitioner the letter counts for the petitioner submits that the parties the allegation against the petitioner is so letter counts for the petitioner submits that in fact the petitioner was in a relationship with the younger sister of the opposite party number 2 they have also married they have also married to that effect where is that marriage certificate married on
under annex 2 my lord.
no date you tell me on
14/7/23
on 14/7/2023 they have filed the Mangala Mandir Trust.
As per the Hindu religious rights, my lord,
these things are very, very doubtful things.
She also present, my lord, the wife.
Call her. What is the name of the girl?
Minnie Samal. Minnie Samal. She has also filed one affidavit, my lord.
Minnie, ask her. Under 2 settlement. Yes.
In this case, my lord,
yes.
as per
My lord, item number 43 and 44.
44, both the matter.
Both the matters are issued, notice has not been issued.
Notice, despite issuance of notice to the opposite party number 2 due to filing
unutilized
filing of
copy.
requisite at a belated stage.
Late filing.
The notice could not be served. The requisites already filed may be utilized for the purpose of serving the opposite party number 2, leaves the matter in the November, in the month of November, end of November.
45.
May I please, your lordship?
Yes.
My lord, the petitioner of your lordship is in custody since 13/3/2024 for alleged commission of offence under section 376(1), 457, 323.
Yes.
5065.
164, read once.
My lord, I may be pardoned to mention, in last occasion by directed to obtain the 164 report and as well as
You don't have.
that has not been.
Mr. Rahul and Counsel for the State submits that he has not received the case diary in the present case. Seeks 1 week time, leaves the matter after 1 week. Yes.
Oh, blessed.
46.
Yes. Yes, sir. Custody?
Within custody, since 15/4/2020.
Sorry?
15/4.
My lord, I am sorry to say, my lord, this is matter of 376 to N, my lord. And here is 164 necessary, CD has not come.
Sir, police constable, my lord,
Let this.
I have annexed the copy of the statement of the victim.
CD let after 1 week. Mr. Rahul and Counsel for the petitioner, state submits that despite on 8/5/2024, the coordinated bench of this court had directed the Counsel for the State to obtain CD. Mr. Rahul submits that he has not received the CD by way of last opportunity. Why are you wasting time? One week only I am keeping it. After 1 week I'm giving last opportunity. 164 statement is not there. Medical examination report is not there. All these orders are they see the last order. Last order says unable him to get the case diary, medical examination report, and statement of the victim. Can I ignore the order of earlier court? If these documents are not there, I give bail. What will happen?
That should become my letter.
What will happen? If the coordinate bench has passed some order, I have to comply that order. By way of last opportunity, 1 week time is granted to obtain the case diary, medical examination for the victim recorded under 164 CRPC. Please the matter after 1 week.
Date case.
47 kindly pass over. 47 pass. Yes.
48.
48 also, my lord, CD has to come, my lord, matter 302, my lord.
CD?
Yes, my lord.
In pursuance to the order dated 8/5/2024, CD of the case has not been received by the State Council. Hence, last opportunity granted, leaves the matter after 1 week. Yes.
49.
May I plead the lordship, my lord? 51 kg. Final charge sheet submitted. Custody author 18/4/2024. 18/4/2024. No criminal antecedent, my lord.
Granted me. No criminal antecedent.
On
recovery is 54.
51 kg.
51 kilos of ganja. He is in custody since 18/4/2024. Subject to verification for the antecedents.
Subject to verification.
Yes, subject to verification. Yes.
50 million CD has to come.
CD has taken 41 CD. 41
I'm not inclined to enlarge the petitioner on bail in view of the fact that during the investigation, the petitioners have approached the court for grant of bail, which has been rejected by the court below. Subsequent thereto, charge sheet has been filed on 29/7/2024. Therefore, in the changing circumstances, petitioner should approach the court of first instance by renewing the bail plea. With this observation, petition is disposed of. Next.
51.
Yes.
May I please, Your Lordship?
Yes.
System of custody since 19/3/2024, Your Lordship.
Sorry,
19/3/2024, Your Lordship.
19/3/24. Okay.
Offenses under section 394, Your Lordship.
394. Okay. Antecedents?
Antecedent, no antecedent, Your Lordship. Only the my name is not in the FIR, Your Lordship. माने से जो FIR allegation अनुसार से जो प्रेजेंट इनफॉर्मर खाली कहिसन जे 4 जन लोक गोटे गाड़ी 9663 रे आसी मते मारपीट करी मो पाखरु जिंस लुटी नेले on basing upon that
CD is required, my lord.
Investigation completed.
My lord, nothing, only this paper is shown.
Why? That is the whole difficulty. Na? This is very difficult to decide the bail application.
No,
Put
my
an
lord,
FIR, one page FIR and give me bail. Nothing is there. Everything has to be presumed and grant the bail.
My lord,
That's it.
last occasion CD and CD and he was called for, Your Lordship.
CD called for?
My lord.
Already called for CD.
My lord.
The CD by the order dated 8/5/2024, CD for the case has been called for. However, Mr. Rahul has gone for the state submit that he has not received the CD. By way of last opportunity, one opportunity, it is directed that the state council should obtain the CD, leave the matter. Yes.
My lord, I pray for short date, Your Lordship.
Yes. Yes, sir.
May I please, Your Lordship?
Custody?
Krishna is a custody since 3/9/2020, Your Lordship.
3/9/2020. 20, okay.
Offense under
20.
Yes, Your Lordship.
Yes.
Offense under section 376(2) and 376(3), 365. Laid in POCSO Act, section 3,
Yes, you forget.
My lord, 376(3) POCSO and 3 SC/ST, my lord. Regarding the regarding the service of notice, there is no information, my lord.
Notice?
No name in the
service.
Huh? Just check it out.
No name in the FIR.
Hmm?
No name in the FIR.
Maybe charge sheet has been filed, name
Yes.
FIR what or Charge sheet, what is the allegation in charge sheet? Here also nothing is filed.
And he has not filed the requisite. The
Requisite
requisite he has
filed.
not filed. Neither consolidated cost title nor the requisite has been filed by the learned counsel for the petitioner. There is
What
no
are the
notice.
notice? File করবেন। Notice.
File করে দিন।
Requisition, file.
Huh? Has he filed the requisites or not?
Requisites has been filed.
Requisites have been filed.
But noting is that not filed.
Has been filed.
No, neither consolidated cost title nor requisite has been filed by the learned counsel for the petitioner.
Neither consolidated. Not filed.
You don't want a bail then. You are wasting time of this court. Right on. Why do,
Within one.
5, no, I will dismiss it and repeat your bail application. By 8/5/2024, the court has directed issuance of notice to opposite party number 2. And file consolidated title of bail application within a week. However, the petitioner has not neither filed the requisite nor filed the consolidated bail application. Therefore, the notice could not be issued to opposite party number 2. At this stage, I am not inclined to entertain this application for grant of bail. Hence, the same is dismissed with the liberty to the petitioner to renew the bail fee before the trial court. And if such bail application is moved, the same shall be considered on the available record within 15 days from the date of moving the application.
Okay.
With this liberty, the petition is disposed.
Hon'Ble.
Yes.
On behalf of my friend, I am saying next week he has to file the deposition.
Deposition, you tell me when the deposition is, when the
12 witnesses examined.
12 witnesses,
All of
when?
Behalf of my lord.
No, when the two witnesses were examined?
Okay, on behalf of my.
See, bail matters, I'll dismiss or I'll grant.
Move on time, maybe move sabu karibi.
So that's the problem, the problem is, it is very difficult, the other people are waiting for listing. And your matter is listed, you are asking for adjournment. I'm not telling you, What is happening is, if this matter would not have been listed, some other application would have been.
On behalf of government.
My lord, preliminary charge sheet was submitted on 6/3/24. 6/3/24. Preliminary charge sheet was submitted.
Fine.
After that, a rejection order was on 11/4/24. But my lord, offense is under section 3762J and 354B. He is a deaf lady, 50% my lord, that is physical handicap. And a requisition was placed for engagement of one interpreter for a recording of 164 statement. But he is saying that deposition copy is there, let him file the deposition copy. But my instruction is that
If the deposition has been, when the deposition has been, after the rejection order?
No, rejection order nothing has been stated whether the witnesses are examined or not. Nothing.
So that is, the trial court has not considered at all this aspect.
If deposition is there, let he.
I'm wondering why the trial court has not dealt with this. Right on. By order dated 11/4/2024, the trial court has rejected the bail plea of the petitioner. Learned counsel for the petitioner submits that the victim girl in the present case has already been declared.
Some witnesses.
And victim girl and other material witnesses have been examined. From the perusal of the impugned order, it reveals that the trial court, while rejecting the bail application, has not dealt with any of the material which has come on record. Therefore, the petitioner should repeat the bail application, renew the bail application before the trial court, and the trial court is directed to dispose of the bail application on the basis of material already came on record, on the basis of materials already in common record. If such application is moved, the same shall be considered within 15 days from the date of moving the application. With this observation, the petition
Without being influenced by these.
without being influenced, and it is made clear that the trial court shall dispose of the bail application without being influenced by the observation already made by the court at the time of disposal of the earlier bail application. That's a better idea. You argue everything, you make it. Yes.
On behalf of my friend. 54.
Password.
Okay. May I please, your lordship?
Yes.
18/4/2024 below commercial quantity 105 4/2024.
The same thing you told in the earlier matter also. Same day. Co-accused.
105 gram of brown swan.
Antecedent-
Antecedent, no antecedent, similar nature.
And he is the only person from whom brown sugar is not co-accused. He is the only person.
সেটা গঞ্জেই ছিল, এটা brown sugar.
এটা brown sugar.
Brown sugar. Commercial, below commercial.
Below commercial.
Below commercial quantity, how, what is the gram? How,
105 gram.
105 gram. Granted bail and antecedent, subject to verification appendix.
Similar nature.
Similar nature. Yes.
Okay.
And antecedent, both.
Similar.
Custody since 18/4/2020. 24.
May I please, your lordship?
Yes.
My lord, in course of day, I am filed the extra copy of the bail petition 376.
Sorry.
Yes. I am not filed the extra copy. In course of day, I will file the extra copy.
Like course of, tell me whether you have a merit, case on merit or not. Yes. What is the offense?
56.
363.
56.
56, ma'am.
Item 56.
My lord. Requisite not filed, my lord. In course of day, I will
It's not
file-
required, my lord. This is 3763 is there. Notice has already been served to the informant on 21/7/24. And charge sheet was submitted on 3/6/24.
And
Rejection order is 24/24.
no, 1 minute. Requisite filed, nah? No, not filed. Okay. When the charge sheet filed?
Charge sheet submitted on 3/6/24.
3/6/24.
Rejection order is 24/24.
24.
24.
20?
24. 20 April 2024.
20.
24.
24. 24, yeah? 24. 24. Right on. By order dated 9/5/2024, the coordinate bench of this court had issued notice to opposite party number 2. In a petition is accused in so and so. By the order dated 9/5/2024, the coordinate bench of this court has issued notice to opposite party number 2 and directed to file the consolidated cost item also. However, the petitioners have not complied the said order. From the perusal of the record, it reveals that on 20th/4/2024, the bail plea of the petitioner has been rejected by the trial court. During that time, the investigation was going on. Subsequent thereto, on 20/4/2024, 3/6/2024, 3/6/2024, charge sheet in the present case has been filed. Therefore, in the changing circumstances, the petitioner should renew his bail plea in the court of first instance. Hence, I am not inclined to entertain this petition. However, granting liberty to the petitioner to renew the bail plea before, if such bail application is moved, the same shall be considered on the basis of the material form part of the charge sheet. With this observation, petition is disposed. Next. Yes.
May I prefer 54, my lord?
Yes.
54.
Pass over? What? 57 I am taking, sir.
Sorry.
Yes.
57 I am on BC.
Yes. Yes, sir.
Custody since 7/1/24, my lords.
7/1/24.
2024.
7/1/24.
24. Okay.
Yes, my lords. Under charge sheet
Yes.
376(2) and 376(2) and I, and read with section 6.
376. Yes.
376(2)(8).
Yes. Charge sheet filed?
Charge sheet
on
committed on 2/3/24.
3/24. 2/3/24.
And the rejection order is, my lord, 22/24.
Yes. What do you have?
My lords, there is a before a conceptual relationship. She never mentioned the time of, never mentioned the day and night of the occurrence, my lord. Only she said 12, time 12. She never mentioned the night and day because there is many houses near cashew nuts. Even she went daylight villages, she might have seen by different villages also.
That's your argument. She has not mentioned the timing.
Not with timing,
Of the
my lord.
commission of-
Day or night,
Yeah.
my lord. She mentioned ମତେ ଡାକିଥିଲେ ବା ବିସ୍କିଟ ଦେଇକି ମତେ ଡାକିଥିଲେ ମୁଁ ବାରମ୍ବାର ତା ପାଖକୁ ଯାଇଥିଲି।
Mentally retarded lady. And on the medical examination report, that 5 months pregnancy was there. Perhaps she might have been given birth to a child. And rejection
Let
order.
let him renew the bail.
My lord, after
Right.
that, charge sheet was submitted after
Right.
rejection.
The petition is accused also. The bail plea of the petitioner was rejected on 28/2/2024. Subsequent thereto on 2/3/2024, March. Charge sheet has been filed against the petitioner for alleged offence under section 376 2N bracket I of IPC, read with the section 6 of POCSO Act. In view of the fact that since the petitioner's bail plea was rejected during the course of investigation and charge sheet is subsequently filed, the petitioner is given at liberty to renew the bail plea before the court below. And the court below is directed to decide the bail application on the basis of the material form part of the charge sheet. To this observation, petition is disposed of. Next.
58.
May I please? Notice was issued, my lord.
Yes.
But
Sir,
notice or
service-
on 36/24.
Okay. What is the allegation? 376 and
3761 POSCO 596 prevention of witch-hunting.
yes. 164 read.
Let it come next week, my lord. In the meantime, victim girl already been examined. I produced the certified
Then
copy.
you
Renew your
No,
bail before the court.
your lordship keep it to
No, why should
next
I?
week. What
See,
happened, my
pardon
lord?
of this court.
Now
you
the
just see.
noting is there, my lord. Neither notice or not ready back.
No.
They do more ready not
and
the next week. Yes.
And notice also sought, my lord. That is.
Notice of
Yes, next week.
so see bail
Both way
application was
notice back.
rejected 9/2/2024.
9 to 24, yes.
Yes.
Keep it to next week, my lord.
9/2/2024. Meanwhile, the victim has been examined. So
Examined.
you should ideally renew bail
No,
there only.
just now I received the information. Your lordship keep it to next week. That's why, my lord.
Next week I can't.
1 week after.
Because see,
Yes,
these courts are overburdened up because of
I-
this kind of petitions unnecessary.
1 week
That's the whole
after.
difficulty. If you have a case, tell me, I'll grant bail immediately without waiting time.
ମୁଁ ରେଡି ନାହିଁ କାହିଁକି ନା ସେ ନୋଟିଂ ଟା
ready
ଦେଖି
ନାହିଁ,
ରେଡି
that's
ନଥିଲି
the problem.
ଆଜ୍ଞା
Problem. On the request of the land counsel for the petition submits that the victim in the present case has already been examined. He wants to place the testimony of the victim on record. Lease the matter on his request. Give it no more. Yes.
59 also same man.
59 November. So November ends.
November man. Last week.
No.
October
Then argue
3rd.
the matter.
See,
No, no question. I will put it in December. Or otherwise,
yes.
Argue the matter. I am ready to hear as much as you want.
My lord, 59.
People are waiting for the listing, and the matters are listed. You are asking for adjournment. If you have a case, tell me. I will grant bail. Slightest
ସେଇ
thing,
ନାଇଁ
fine.
ଆସିଯିବ ତ ସେଇ ଯୋଉ ମୁଁ କହିଲି
So better would be you renew your bail plea and come. That's a better idea.
ଆସିଗଲେ ଆପଣ ଦେଖିଦେଲେ ଦେଇଦେବେ
ଦେଖିବି
ଯଦି
November. By that time you will get it. Wait. What to
ଆଜ୍ଞା
do?
59 minutes CD was called for
59.
59
CD is there.
302 CD required.
CD is not there.
No.
So then, by order dated 9/5/2024, the coordinate bench of this court has directed the petitioner to state council to obtain CD, which has not yet been received by the council. Hence, by way of last opportunity, 1 week time is granted, least after 1 week.
66 co-accused
No, 64.
Of 59, huh?
ନାଇଁ 59 ର co-accused ଟା 66
These are same order.
ଆଜ୍ଞା
These are 66 and 59. Tag list both the matter together.
ଆଜ୍ଞା
After on 1 week. Let the CD come. Yes. 60.
60. May I please, Your Lordship?
Yes.
Your Lordship, the present petitioner is in custody since
Since
1/2/2023, Your Lordship.
1/2/2023.
2023, Your Lordship.
Okay,
Yes,
madam.
Initially, FIR was registered under section 302 against an unknown person, Your Lordship.
Yes. Charge sheet filed?
Yes, Your Lordship. Charge sheet has been filed. Trial has also substantially progressed, Your Lordship. Since the FIR and the charge sheet and the charges have been framed under Section 302, Your Lordship. Now, after the examination of the post-mortem doctor, Your Lordship, since there is a specific finding that the cause of death is suicidal in nature, Your Lordship. So that is why we have moved an application before Your Lordship. We had also moved an application before the learned session judge. However, the learned session judge said that, court in session said that if the petitioner is released from bail, there is a chance of terrorizing the witnesses, Your Lordship. However, all the material witnesses have been examined, Your Lordship.
And totally case is based upon the evidence of the doctor, madam. Because
Doctor said suicidal.
doctor says my suicidal hang. But witnesses, my lord, all the witnesses, they have stated when they seen the dead body, that the foot of the dead body was tossed to the ground. All are stated.
And they have
And my
turned
lord-
hostile.
And my lord,
And
the
all
death
the
is-
witnesses have been examined.
No, my lord, not all the witnesses.
Most of the
Most
material
of the
witnesses.
witnesses are examined. And doctor has examined. He
Doctor was
stated-
examined when?
My lord,
Your
doctor
Lordship,
was
doctor
examined
was
on-
examined as PW 12
When?
and PW 13.
When? Date?
Doctor was. Lordship, the date is not there in the certificate.
My lord, actually, one objection that deposition copy is not in the proper format. What he has.
No,
That
you
is-
tell me when the objection.
That is not,
That
my lord,
is
date
what
is not
have
there.
been
His
provided.
name is written.
That PW 12 and 13, Your Lordship, and that has also been considered by the learned court in session in page number 13.
13.
Yes, Your Lordship.
What do they say? Yes. Yes.
The materials available on record clearly make out a prima facie case under section 302. Before that, Your Lordship.
No doubt.
Yes, Your Lordship. Note of the doctor who conducted autopsy over the dead body of the deceased has opined that the death of the deceased seems to be suicidal in nature. And the statement of the doctor, both the doctors, is that the death of the deceased seems to be suicidal in nature. This is the specific finding. And there are no other injuries in the body, Your Lordship. Admittedly, there was an extramarital affair between the petitioner and the deceased, Your Lordship. Both are neighbors, Your Lordship. The petitioner used to work as a farmer in the lands of the deceased, Your Lordship. The husband of the deceased was staying outside and there was
Then
an
why can't
extramarital
he
affair, Your
granted
Lordship.
bail?
My lord, what
I
happened?
am in
My
custody
lord,
for
what happened? The
1.5.
opinion of the doctor, same old doctor. Opinion is that, my lord, death can be possible by suffocation. Allegation is also that. And all are stated that the deceased leg was tossed to the ground, my lord. And the minor
You
daughter.
read out any evidence.
My lord, minor daughter PW 14.
Yes,
Is
Your
that
Lordship.
the minor daughter of the deceased, my lord.
Yes.
That
PW
PW
14.
14, my lord, can you say?
14. Okay. Come on. Yes.
My lord, para 3.
Para 3. Read it now.
My lord. On getting such information, I, along with Rina Bhaujo, Sanju Bhaujo, my elder father, Satyanarayana, and other villagers, went on to the spot. On reaching the spot, I found my mother was hanged from the tree by means of a sari, and her feet was touching the ground, and her face was covered with scalp hair. My elder father entered the sari hanged from the tree. We sprinkled water on her face, expecting my mother to be alive, but she did not regain her sense. My mother was shifted to
Yes.
another place.
And what about the other witness?
Then my another next time, my brother disclosed me. That is important, man. My brother disclosed before me that a person was hanging his mother from the tree. He went to the spot to see who was hanging from the woman from the tree. That
That is
terrorized
not
him.
there, Your Lordship. That evidence is not supported by other witnesses, Your Lordship. By other witnesses.
Then my lord,
Brother is examined.
Minor son was not examined. Minor son who has seen, and he is also stated that to whom he has seen, he is the present petitioner. He has not been stated.
Your Lordship, FIR was registered against unknown person. Yes, Your Lordship.
Cited as a witness.
He has been
Vital witness.
No, Your Lordship. What my contention is that, Your Lordship, even if they're saying that it is a case of eyewitnesses, Your Lordship, in the registration of FIR, it is against unknown person, Your Lordship. And he is not saying my name while disclosing to others.
Who is the author of the FIR?
My lord?
Author of the, Your Lordship may see the author of the FIR.
Is who is that?
Yes, Your Lordship. The author of the FIR
And
is
informative
Saraswati Sial.
Huh?
Saraswati Sial, Your Lordship. This person.
But the daughter and the minor son.
Yes, Your
Both of them have said that
They have not said, Your Lordship. That is what is my contention. She is not saying that in the FIR, Your Lordship.
FIR they may not be, but in the
even after
deposition-
that, in the
deposition this has come.
164 also, your lordship, has been recorded, your lordship. 164 has been recorded. Thereafter, they
How
have come
get
to
out
this
of
court.
this evidence? She said that touching the feet, it's one.
Your lordship,
And
even
that is,
if-
that
your
is
lordship-
being corroborated with the other witness.
Your lordship, that is what I'm contending. The fact that the feet is touching, to consider whether it is a case of suicidal or homicidal in nature, the nature of ligature mark is to be seen, your lordship. Both the doctors have conclusively opined that the ligature mark was oblique in nature, your lordship, even if the feet is touching. She has struggled while she is committing suicide, your lordship. The ligature mark is oblique and the
But
doctor.
the minor son has seen that you.
Minor son has not seen, your lordship. That's
what-
the
that's what- that's what-
your lordship. That is what she is saying. That
So she, the minor son is cited as a witness.
yes, your lordship.
If she will come, he will come and say.
Your lordship,
That
if-
I saw the gentleman tying the.
Your lordship,
dead-
that is what is my contention. He saw that the gentleman was passing from there and was wearing the same napkin. He did not see that I was hanging the body, your lordship.
I'm not here to accuse you, but
Yeah,
just
and
the
my lord, that the
overall evidence.
doctor's opinion is not only the conclusive proof. There
Yeah,
is
That's
other
what the
evidence.
trial court says. Wait till the minor son is acquitted.
Your lordship, may I
Yeah.
request one thing?
Yes.
I may be given one more chance, your lordship. I will place the evidence of the minor son, your lordship. Because the other
Then
witnesses
counsel
have,
for the petitioner submits that he may be given one opportunity to place on record the testimony of the minor son of the deceased.
yes, your lordship.
Minor son of the deceased, release the matter after 2 weeks.
Much obliged, your lordship.
If minor son, you can make out a case, then
Your lordship, I'll place
In
that.
document added that he filed the deposition copy in the, though it is in proper format because.
We
it's
have
not
applied
proper-
from the court. I will try again.
See one. Pass over.
pass over.
62.
I may be allowed to move my lord on behalf of Mr. Gopal Naik.
Yes.
My plea lordship. 307 is the offense. I mean custody since my lord 6/4.
Is there?
My lord.
Yes.
I mean custody since my lord 6/4/2024.
6/4/2024.
In the meantime, if the charge sheet has been submitted, as well as the case has also been committed to the court of session.
Yes.
But trial has not been commenced.
Yes.
Any
That is
cause-
a charge sheet submitted one.
My lord.
On 23/2/24.
Okay. Okay.
No, no. Charge sheet
Yes.
submitted on 25/2/2020.
23, no?
25 to.
What are the
2020.
allegation against you?
Allegation, my lord, if you also have regards to the affair, that the petitioner and other 2 persons came to the petitioner and along with 2 persons came to the house of the injured and took him with them in a motorcycle. And after some time, 2 persons came to their house and gave the information that the brother of the informant is sustained some injury and lying inside of the room. The brother went there and found his brother is lying there, took him to the hospital. Thereafter, he was treated and also now he is well.
307.
307.
And
What is the injured says?
Grievous injury is there, man.
Injured says. What was the injured?
For
says?
injured also.
Injured
The
statement.
injured statement is not available, my lord. In the case diary, injured statement is not.
That's the vital thing.
Yes, my lord. I have checked.
He would have said what exactly who has done it.
My lord, that I have checked.
The,
My lord, that injured
But
statement.
everywhere, my lord, that they have stated petitioner along with 2 others.
Do you have injured statement?
No, that statement is not.
Injured
with me.
statement is required to know. You are in custody since February only. I don't. The statement of injured in the present case is not available with the state council. He seeks 1 week adjournment to avail the statement of the injured. Leaves the matter after 1 week. Yes.
63. May I please, your lordship?
My lord, the allegation of 376, my lord, to end, charge sheet submitted on 23/2024 and the rejection order is 4/4/2024, my lord. The victim is a married lady.
23?
My lord, 4/4/24, 23. 24, charge sheet and rejection 4/4/24.
23/4/2024.
20, 23.
23.
Again. 4/4 which
Okay.
rejection order
Okay.
and custody 22/1/2024.
22/1/24.
24. Victim is a married.
CDS. CD na.
Sydney.
Victim is a married lady
Allegation is that
having 2 children.
given some mixed item in cold drinks
That
and
is in the year
cocktail red, that is
2022. The
allegation. CD complaint.
allegation is 2022.
20?
My lord. Since 2022 to 2024, there is a relationship between the two.
Show me something, 164 something.
My lord, 164, my lord. Now the police paper, my lord, I have received, my lord.
The
Medical evidence.
original incident is 2022.
22.
Just
Started from 22. It was started
Started
from 22,
when?
continuing 22.
Then
So it continued till 24. And medical evidence is
give it to him.
My-
Pass over.
my lord.
Pass over. Huh? If they had relationship for such a
Yes,
long time,
ma'am.
what is? Give a copy to him and get a copy for me also.
Then I will.
I am also entitled to
Yes,
read.
my lord. Yes, my lord. Just I'm.
Pass over, huh? Pass over.
Those are-
Just
May
take it up.
please,
Next 64.
May please. My lord, the petitioner custody since 15/2/2024.
15/2/2024. Okay.
And the charge sheet filed 7/4/2024.
7/4.
7/4/2024.
Yes.
Rejection order is 29/3/24.
You have to go to what is the offense?
So 3762N
Oh.
and the medical exemption,
Right.
there is
Petition-
injury and the victim was
petition-
7 months pregnant.
Okay, petition is agreed by the order dated 29/3/2024, whereby his bail plea has been rejected. Subsequent thereto on 7/4/2024, charge sheet has been filed. Since the bail plea of the petitioner was turned down by the court below at the time of during the period of investigation, and subsequently charge sheet has been filed. In the changing circumstances, petitioner shall renew his bail plea before the court below. If such application is moved, same shall be considered on its merit. Yes, next. 65.
65, my lord,
On
376.
behalf of Mr. Jena, I prefer adjournment.
You want to argue? Argue?
Adjournment.
Sorry? Adjournment.
Yes,
No adjournment, very difficult, madam.
On behalf of.
Because
Mr.
everybody is asking for adjournment, then I'll have to stop listing the matters. Bail matter by here you are. If you have a case on merit, I'll give you the bail immediately. Try yourself. What is the offense?
3762N.
376. All possible offenses. Charge sheet filed?
That instruction CD not available, though I do not have knowledge whether charge sheet was submitted or.
These matters are pending, you know.
13/5/2024, first order was passed.
Huh?
On 13/5/24, this honorable court has directed for case date.
See, these bail applications are pending since about a year. And we are trying to list all the matters, and you are seeking adjournment, and unnecessarily the court is blamed that matters are not being heard.
Actually, my lord,
What to do?
though the matter was listed after 3 to 4 months after first order was passed.
See, bail should be heard within 10-15 days.
That is correct, ma'am.
And why this is happening, you know, because
Though
of
there
the
is
attitude,
very-
because of this attitude. If bail is listed, you argue this way or that way. It rejected it. There is no res judicata. You can renew your bail plea. At least we should hear the bail application as quick as possible. And I'm surprised that bail is listed and adjournments are sought. What to do? If there is something, just tell me. And nothing is filed. I can't. There is no assistance also. Except FIR, nothing is filed. How will I come to know? Allegations are serious.
Allegations are serious. 66 IT Act is there. 66 IT Act is there, and allegation has also, she has taken naked photographs, everything.
You tell me whether investigation, what is the stage of investigation? Because the FIR is registered some 2024, March 24. Rejection is 27 March. You renew paper, write down. The FIR in the present case is registered on 15/3/2024 for alleged offence under section so and so, page 9. Page 9. Immediately, the petitioner moved application for grant of bail on grant of bail. which was turned down by the trial court on 27/3/2024. Obviously, charge sheet might not have been filed within 15 days. The petitioner is in custody since custody since
Custody since 16/3/24.
16/3/24. Since the petitioner bail plea was rejected by the court below during the investigation, and subsequently investigation has already progressed. The petitioner shall renew the bail plea before the court below in the changing circumstances. And if such bail application is moved, the same shall be considered on merit on the basis of available record. With this observation, the petition is disposed of. Yes. You 67. Did you follow, madam, what I did? See, on 15th, the FIR was registered, and immediately you move an application. On 27th, our application is rejected. So now investigation might have been might have been progressed. So you renew the bill. No. Pending means I'll give it in the month of December. There is no scope of giving. No. Password also the same. Same order will I will pass.
67, my lord.
Madam, the counsel for the petitioner has vehemently argued the matter and taken me to the record. Taken me to the record to make out a case for grant of bail. However, I am not inclined to entertain the bail application at this stage. I have recorded your thing. Okay. Yes. It's all right. Same thing I will pass. Don't worry. Yes.
Petitioner is in custody since 19/3/24, my lord.
67.
19/3/24, my lord.
19/3/24.
19/3/24.
Okay.
Initially the informant was eloped with one Debasis Behera, my lord. On 18/5/23, my lord, FIR was lodged by the father of the informant regarding kidnapping his daughter by Debasis Behera, my lord. Subsequently, the victim was rescued, and her parents gave marriage to the present petitioner, my lord. After some days, my lord, she again went away with the previous lover.
That what is his name?
Debasis Behera. And FIR has been lodged against the present petitioner is the husband and her parents and aunt.
For offense?
Offense under section 340.
Why they have lodged FIR against you? She has eloped with that Debasis.
Also lodged FIR. Annexure 4, I have Annexure 2, my lord, may kind glance. Debasis Behera said the first she was eloped on 18/5/23, my lord.
What happened to that case?
That case, my lord, I have annexed. Final report was submitted.
Okay.
Final report was submitted.
And thereafter you married with the victim girl?
No, my lord.
Who married with victim? Debasis.
Thereafter her parents gave marriage to the present petitioner, my lord.
That's what I'm saying.
As per their rights and Hindu rights and custom, my lord.
Then you are become husband.
Husband, my lord. Only allegation is that.
Till that time, minor girls.
That's right, but you are the husband.
Husband, my lord.
And
Admittedly.
what is the allegation now?
And also in the FIR, my lord, lots of mechanic is a peculiar case. FIR will extend the annexure 1 re.
Yes.
जबरदस्ती देवगढ़ जिलार विजय कुमार दास सहित विवाह कराइथिले 18 वर्ष होई नथिबा जानी विवाह करिया पई से राजी होइथिले.
Who has written this FIR?
My lord,
Who is
the victim Pratyusha Pal lodged the FIR.
She is victim
against the parents and against her husband, my lord.
What is this?
And thereafter, my lord, page 13, my lord, also mentioned କିଛି ମାସ ପରେ ମତେ 18 ବର୍ଷ ହେବା ପରେ ମୁଁ ପସନ୍ଦ କରୁଥିବା ଦେବାଶିଷ ବେହେରାଙ୍କୁ 6/1/2024 ଦିନ
very dicey thing. I am granting bail. Petitioner is accused so. who was filed the second FIR? Devas against Devasis, same girl.
Victim. No, previous one, his mother, her mother was filed.
The mother of the
Now victim
victim
is
earlier had filed Hon'Ble PS case number 237 of 2023 for alleged offence under section 363 against one Devasis
Devasis
Behera. After investigation, the case was culminated into a final report. Final report on 2/6/2023. The parents of the parents of opposite party number 2 appears to have got the petitioner, got the victim married with the present petitioner. On marriage on
date has not been mentioned, my lord.
got the present petitioner. Present petitioner. Since the opposite party number 2 is in relationship with the one Devasis Behera, she has filed the present FIR against the petitioner and his family members, inter alia alleging that she is a minor and she has been forced to marry the petitioner, forced to marry the petitioner. On the basis of the said allegation, the present FIR is registered. The petitioner is taken to custody on 19/3/2024. The parents of the petitioners are also co-accused along with the petitioner.
Yes,
It has come on record that the petitioner has in fact married with the victim girl. The victim girl. The victim girl is not satisfied on the marriage. Rather, she is in relationship with Devasis. Devasis Behera. That is the reason for registration of the present FIR. Regard being head to the peculiarity of the facts and nature of allegation and the fact that the petitioner is in custody since 19/3/2024, I am inclined to enlarge the petitioner of the bill. Accordingly, the petitioner is mentioned. Yes. Take up your I'll take up this matter.
Yes. This is squarely covered by your
Yes.
lordship. Item number 100. Yes, my lord.
150.
Yes, my lord. Here, the financial aid is.
You show me when you deposit.
Yes, 13/14, my lords. My lords may be pleased to give me my reply. Annexer 4 at page 12.
4?
Annexer 4 at page 12.
Yes.
The
yes.
amount of TDS was 13,18,732.
Yes.
And para 1 lordship may be pleased to see.
Yes.
With interest, this has been deposited before the launch of prosecution. The complaint was filed.
When have you deposited?
I have deposited in the month of July, my lords.
Can you give me the date?
Before the launch of prosecution.
Can you please give me the date?
No.
July, huh?
Yes. Before July, I have given.
July 2017,
my lords. And the prosecution
Please,
was
please
launched.
try and find out to give a date, yes.
Yes, Lordship may be pleased to see.
And when the complaint was filed?
Complaint was filed in October 2017, my lords. I'm giving-
Date.
Yes, the Lordship may be pleased to turn to page 30.
Give me the date.
Yes, yes. The date is, my lord. Lordship will be pleased. That is before. Yes, 25/10/2017. Lordship will be pleased to see page 30, my lords.
30.
30. To copy the complaint petition itself. So, last page of the complaint.
Yes.
It was filed in October 2017.
Yes. Where have you in the petition, where have you said that you have deposited?
My lords, I have in my so cause to the sanction, so cause for sanction. There is annexer 4 at page 12. May be pleased to please be seen.
12.
Yes. Page 12, para 1. When I was given the so cause as to why prosecution shall not be lost, then I replied.
Where have you said you
Para
have
one-
not said when have you deposited the amount? That's the,
And deposited the same along with interest to the credit of the central government, my lords.
hey, tell me the date, sir.
Yes, yes. I'm giving.
Unless you tell me the date.
Yes.
In the SOCAS also, you have not said anything.
No, I have said that I have categorically stated that I have deposited the amount.
But I need to know the date. I reconcile that with the
Yes,
complaint.
Lordship may
Your
kindly
Lordship,
give me-
but my contention that this is not applicable because all the order you have passed, it was, you have given the relief due to COVID-19, all the relief.
No, the last order which I passed, where
Yeah.
I said that
Yes.
the moment you accept the
Yes.
interest part,
Yes.
along with the TDS amount,
Correct, madam.
then thereafter you can't.
Can prosecute.
yeah.
And that has been confirmed.
That
And
has
that
been
has been
confirmed.
confirmed by the Supreme Court, my lords.
Yeah,
I give it that judgment. Yes.
I
See,
have
the ratio,
Your Lordship, I am having the Supreme Court judgment where it says that even if you have paid tax and interest, prosecution lies.
That has been also diluted by the Supreme Court. So much water has flown through the Ganges.
In Madhumilan Senex
it is
Limited
that-
versus Union of India.
Reasonable cause.
see, I'll read.
Yes, your lordship has-
Pandemic is one of the issue.
Yes.
The petitioner directed the covered by the judgment cited by Dev multiple so and so.
Yes,
so.
that has been also. offered in
Supra,
the-
because the prosecution indeed has initiated by the opposite party against the petitioner after having received the TDS amount along with the interest.
Interest.
This part of
This
the
is-
judgment is now.
Sanjay Kumar Nanda, Your Lordship, they have passed. That also relates to the COVID period.
That's a story. COVID is one of it.
And this is prior to the
Prior to
COVID period.
2017.
And
My learned friend is incorrect. That is he has forgotten section 278AA, which says that there should not be any prosecution where there is a reasonable cause.
Your Lordship,
Yes.
I'll also explain that reasonable cause, Your Lordship.
Reasonable cause. and
No
you have
reasonable.
What is the delay? What is the delay in your
Delay
part?
is by law 3 months to 12 months.
Are you are not you can get the benefit of that notification
Yes,
also?
notification.
Circular?
That yes, sir, that circular.
The circular, how will you get out of the circular?
Circular mallards.
Your Lordship, in here, the reasonable cause, what he's saying, that reasonable clause, he has not explained any time. That's why the prosecution was launched.
They themselves, they themselves in the complaint petition have admitted, my lords, that there was a delay of deposit between 3 to 12 months. That your lordship be pleased to see at page 31 of the complaint petition. The copy of the tax deduction statement that is from Form 226Q also corroborates.
What happened to that Jharkhand judgment?
That has been upheld in
Upheld by the Supreme Court?
Yes, yes. That has been upheld.
Yes. Yes.
Your Lordship.
SLP.
Yes,
order.
SLP. That confirmed.
SLP.
I'm just.
No,
Lord. Sorry, madam, but I have given already.
Yes.
Another copy, my lord, may please to see by Justice Dhulia, and they have dismissed the revenues.
Yes. Give me.
Yes, another copy and my lord.
The same one?
Same one.
Same one.
Yes.
Okay. That is DN Homes.
DN Homes, my lord followed DN Homes.
I followed DN Homes.
Yes. Not
But
borrowed.
DN Homes is only on the basis of pandemic thing.
Pandemic, and also there, my lords, this honorable court has explained, so far as section 278 AA is concerned, is reasonable cause. And I have given reasonable cause, I have described in my so-called notice as to how para 4 of page 13, lordship may be pleased to see.
Para 4?
Para 3 and 4
of
the so-called notice, my lords, which was given in compliance to the notice.
Yes.
Issued under section 279.
Para 3 and 4.
Yes. Survival of the assessee in tough situation and huge amount of investment in fixed cost, delay in payment by contractee, and the pressure of payment to the creditors compelled the delay in TDS deposit. Even it became difficult to collect the outstanding amount from the mine owner.
That's what you say, it is a sufficient reason.
Yes.
This is sufficient.
Yes. 3 and 4.
Anything to
Your Lordship, first of all, I want to say, as per Supreme Court order, even if he has paid tax and interest, prosecution lies. I am submitting this court. Supreme
That's
which
like
is
that,
followed
that,
by,
that is the statutory requirement.
which is followed by also by the High Court of Karnataka. Another thing I also want to say, what TDS deductor, if he deposit in delay the TDS, who is the sufferer? The deductee is the sufferer. He won't get the benefits. Suppose there is a delay of 1 year. So when he file the return, he won't get that amount. We won't get the TDS. For that, prosecution has been launched for that reason.
But on the subsequent year, he'll get it.
No, Lordship, they won't get. The year it will be shown in 26 years, only they will be reflected. They'll get. They will already filed the return. For that reason, the prosecution has been launched. The reason the prosecution will be launched that you have not filed the return within the due days, because the benefit goes to the deductee only. This is deductee amount. It is not their amount, your Lordship. What they do, they deposit the amount which they have to pay to the third deductee. From that amount, they are deducting.
Have you got any complaint from any deductee?
No.
No, Lordship, in this case, what we do, we launch the prosecution by giving opportunity to the parties. They never reply to that. Then we will help for the
Then the agreed person, the deductees, and they have not come forward. And you have accepted the amount along with the revenue doesn't have any grievance.
No,
after having received the TDS amount along with interest.
And
revenue's interest is taken care of. It is the deductee, those who are agreed. Deductees have not come forward to complain.
And Lordship, regarding reasonable cost, that should be explained to the trial court. He'll let the matter may go to the trial court. He'll explain that reasonable cost which has not been explained.
Trial courts are already overburdened.
It's your Lordship.
And if you want to give anything in writing to distinguish the judgment, you must do that. So that
Only,
I can deal with that.
these two judgments may be quoted in the orders.
Motte copy do.
It any court copy it.
Yes. If you want to give written submission, definitely.
Sub item is also 7, same mallet, that is 236 of 2022. That only first is relating to the financial at 13-14, second one is 14-15 mallet. That's all. Thank you, ma'am.
Yes, sir.
Much obliged. Much obliged.
Judgment result. Yes. Within 2-3 days you give it. Right. Yes.
Item 7.
Sir.
My limited there before a lawsuit.
Lordship permit, Lord.
My account has been seized.
His grievance is against the Vigilance Department, but inadvertently maybe he has given the copy to my learned friend in advocate office. The copy may be given to us.
But my friend saying so that on last occasion, Vigilance Council, Mr.
Appear.
He has appeared and prayed before this on court. I am taking the time to take instruction. I have the copy. How he has submitted before.
Okay, it's all right. No problem.
My lord, my wife's account has been seized, defreezed by the Vigilance Department in
But
connection.
the problem today is Mr. Maharana is not well.
Because my lord,
No, he's there is some personal problem.
I cannot. I will cooperate with my friend.
His sister is not well.
In fact, my lords, I've gone through the copies supplied to my learned friend, my lords. This pertains to seizure of certain accounts.
That's right.
And he wants a release of that.
Mr. Maharana has accepted notice and he has the copy. And if you don't have the copy, take it. And since Mr. Maharana, counsel for the vigilance, is having personal difficulty, next.
Can I pray? Because the present petitioner,
What
is suffering because my account has been seized.
Therefore, I am giving a short date.
Oh, my lord.
Yes. After he has said that after 18th he will be there.
Hello.
23 he will be there. So accordingly, I'll yes.
Lordship, in item 8, the matter is amicably settled between both the parties.
Yes.
And Lordship, on last occasion, your Lordship directed to ensure the attendance of the parties.
Yes.
Lordship, I am praying for 1 week time to ensure the attendance.
No, I can't wait.
Lordship,
It has been urgent many times.
Lordship, last
You are
occasion.
settled, you are settled.
Yes, Lordship.
That matter has already been settled. That is on 23rd April 2024. You sought the time saying that I'll bring these people. Then the matter listed on 15/5/2024. You made the same request. And thereafter the matter was listed on 22/8/2024.
Lordship,
Made the same request. And today again the matter was listed on 29/8/2024. Again the same request. Today again the same.
Lordship, we have filed the joint.
Why are you burdening this one?
Lordship, we have filed the joint affidavit. Was
Maybe.
Lordship,
I don't know. I'll dismiss it and you file it. I'll tell you how many days. First day is 23/4. The matter was taken up on 23/4/2024.
Lordship, kindly
The
day
counsel
after
for the petitioner submitted that the matter has already been settled, and he sought an adjournment to file the joint affidavit. And
Exactly, what has happened in this case.
no, one.
I'm quite aware of the facts, madam.
4 times.
But when I scolded I mean, said I banked the local lawyer. He says that, sir, he may not proceed with the case. But I said, you have to come to file an affidavit or to give an instruction not to proceed. So I cannot instruct my juniors to do that. So he expected to come tomorrow or day after. So unless at least a WhatsApp message today, nowadays what is happening, the clients are writing all nonsense things against the lawyers. So unless you without keeping any document or any sort of message from them, to take any steps in any case is dangerous.
I know, that's the problem. We are not in the mercy of the accused.
Yes.
He said that I have settled the dispute.
So I have
and then you have to come forward.
I have instructed.
You can't take the court side.
Yes, I have instructed them at least to give a message to in that respect, but tomorrow or day after, so that
I'll put it day after.
Day after.
On the request, the matter was taken up. I have write down. Matter was taken up on 23rd April 2024. The counsel for the petitioner submitted that the parties have settled their dispute and sought an adjournment for filing joint affidavit and the parties to be present at the court. Subsequently, the matter was listed on 15/5/2024 and 15/4/2024, 22/8/2024. 29/8/2024, on all these days, the petitioner has sought adjournment on the same pretext. And today, when the matter was called up on the after in the second call, the same request is made. Mr. Dowry, senior counsel at this stage appears and says that one more opportunity shall be given. Lease the matter.
If my lord, he will not turn up, then my lord, it will be not pressed.
And it made clear that if day after tomorrow, when the matter is taken up, if none appears, the matter shall be automatically dismissed without automatically dismissed. Yes.
In this appears challenge the DV proceeding, my lord.
This is item
9. DV proceeding, my lord.
Yes.
On the grounds central same is abuse process of court. It has been filed at the belated state after 6 years of desertation, my lord. The marriage was solemnized on.
You are the husband.
My lord.
No, you are the mother-in-law,
father-in-law.
Husband also there.
Yeah. Marriage was solemnized on 14/12/2014. And
marriage still subsist or
still subsist. I filed my lord
divorce petition.
Divorce petition on 9/10/2017. As it did not turn up. She did not turn up. I filed divorce petition.
Is there any chance of settlement?
I think there is no instruction for the such.
I'll straight away send to the mediation.
As your lordship.
Because these are matrimonial disputes.
Yes, my lord. My lord, what is the marriage, my lord? After 6 years of marriage.
That's right. That is the reason I'm.
And there is no such domestic report.
Those things are on merit. I can't go into the merit at this stage.
My lord.
Only thing is, what I can do is I'll issue notice and send it to mediation.
Yes, my lord.
The parties are at Kurda. All of you are in.
My lord, the petitioner is from Baleswar, my lord.
And the matter is pending where?
JMFC, Khurda, Bhubaneswar.
Then it has to be done at the Bhubaneswar only.
My lord, in High Court Mediation Center.
High Court issue notice to the opposite party number 2, opposite party.
Sole opposite
party. Yeah. This is a dispute arising out of a matrimonial discord. Hence, there is all probability that the parties may settle their dispute on mediation. Hence, the parties are relegated to High Court mediation cell and the same.
Till then, my lord, I say. Till then, my proceeding.
1 minute. Issue notice. What is the stage? The matter is pending since 2010, 20. We are in 24.
Yes.
What is happening there?
No, I am paying, my lord, interim maintenance.
Oh, you keep on paying.
I am paying. I am paying, my lord.
Why should I stay 2 weeks after, 3 weeks after?
Only for till this.
You move application there. Application only done. Yes.
May I please, your lordship? I'm extremely sorry I could not able to attend the court.
It's all right. All right. This happens. Yes.
The present petition, my lord, he has filed this petition.
Yes.
Crossing of the FIR because, my lord, the FIR has been filed against the petitioner under section 20B(2)(c) of the NDPS Act, my lord.
Yes.
And the fact of the case, my lord.
Charge sheet has already been filed.
My lord.
Yes.
Charge sheet has filed, my lord.
Yes.
My lord, page 16, your lordship, kindly have a glance.
1/6, huh?
1/6.
Yes. Yes.
The FIR, my lord, first is an information report, my lord. Whereas the petitioner name is not find place in the FIR, my lord. Only it is alleged that 3 persons were in the auto.
That's right. What happened in charge sheet? You tell me.
My lord, I have been charge sheeted, my lord. The petitioner is charge sheeted.
Then,
but on the
in an NDPS case, you have been charge sheeted. How do you expect that I'll pass it?
My lord, as per the section 67 of the NDPS Act, my lord, the Tufan Singh judgment, my lord, there are two contentions the Honorable Apex Court has said, my lord. First is, my lord, that the officer who are invested with powers under section 53 of the NDPS Act are police officer within the meaning of section 25 of the Evidence Act, as a result of which any confessional statement made to them would be barred under the provisions of section 25 of the Evidence Act and cannot be taken into account in order to convict an accused under the NDPS Act, my lord.
Yes.
And second one is that the statement recorded under section 67 of the NDPS Act cannot be used as a confessional statement in the trial of an offense under the NDPS Act. Then I will face the trial, my lord? If the confessional statement is not applicable, my lord, admissible, my lord.
We don't know apart. We don't know apart from confessional statement. There may be some other evidence may come against you. Who knows?
My lord, only confessional that they detain two persons, my lord.
Prosecution will lead evidence. Thereafter, we will come to the conclusion, and that can be argued at the final stage. You argue all this point at the final stage. We don't know today. The trial has not been started.
My lord, I am concerned about the Tufan Singh judgment, my lord.
Tufan Singh judgment is not 482.
My lord, the judgments of any apex court is applicable in all cases.
Not at 482 stage, at the threshold.
When the apex court has said that he cannot face the trial, then the cognizance itself is
any other point? Any other point do you have?
No, my lord.
This point is very weak point. You have to argue all this point there. I am not agreeing with you. The petitioner is.
Your lordship, if you allowed him to surrender and release, my lord.
Come to that point. Come to that point.
That is the real matter.
That is the real point.
That is the last point, my lord.
That's the real point.
My lord,
That's the reason you have filed it, and tell me that straight away. Then we will find out some way out. Your bail application has been rejected already.
My lord, rejected, my lord.
You are in custody.
No, my lord. I am not in custody, my lord.
Absconding.
My lord. He was not present at the spot, my lord. Only from the confessional statement he has been implicated, my lord.
It's all right. You surrender before the court on or before 15th of October. Till then, I will protect you. Okay?
My lord. Okay.
That's a fair idea. Okay. The petitioner has invoked the inherent power of this court under 482 CRPC, seeking quashing of the entire criminal prosecution launched against him by PS case number 187 of 2023 for alleged offense under section so and so. The learned counsel for the petitioner has argued at length regarding the on merits and on merit. I am not agreeing with the contention raised by the petitioner in the present petition. Therefore, the petition is therefore the petition is petitioner fails. However, the contention raised by the petitioners are left open to be addressed at the appropriate stage before the trial court. At this stage, the learned counsel for the petitioner submits that the petitioner may be protected, may be given an opportunity to appear before the court and await remedy under law. On instruction, he says that his client would be appearing before the court on or before 15th of October 2024 and await remedy under law. He may do so. He may do so. Till then, no coercive action shall be taken against the petitioner. Yes. Till then, I have protected you. You go and appear.
Obliged.
Yes.
Obliged.
Yes.
Record may be available at the time of surrender.
Yes, everything will be available. Don't worry. Yes, next.
11.
Yes.
The present petitioner, the chief civil supply officer, has been.
You have the same problem?
No. He has been granted anti-suit rebel after going through the entirety.
Okay.
How a malicious proceeding has been initiated against the person concerned, my lord.
Yes.
By the assistant civil supply officer.
Yes.
Initially, it has been, my lord, the case of the prosecution is like this. As per the direction of the Secretary Civil Supply Department, the present petitioner is the Chief Civil Supply Officer, arrange a video conferencing meeting between the SCSO. There is a meeting held. Thereafter, my lord, the present petitioner.
Charge sheet has been filed?
No. Till today, investigation is going on. Because, my lord, I have annexed the inquiry report, page 35. Your lordship come to page, straightway come to page 35.
Yes.
For that reason, a committee has been constituted by the local authority collector and with the aid and advice of the secretary.
Yes.
What is the conclusion? In view of the above observation, the local complaint committee hold that the complaint has not been able to prove its case against the respondent for the allegation of sexual. That is 352. In BC, where is the offense under section 354A? I have annexed the entire statement of the witnesses, those who are present in the BC. I am the Chief Civil Supply Officer. Being directed by the secretary, I have conducted a meeting. In meeting, because they were doing some illegal activity, even to accepting for a moment, I have given some remarks against the SCSO. For that reason, I have been victimized, my lord. That is the statement of the witnesses. The person, those who are present at the scene in the BC, they have narrated there is no such occurrence, my lord. It has been alleged that our sir saying in loud voice.
The victim was there in the meeting.
My lord?
The victim was there in that meeting.
In the BC, my lord. He is one of the SCSO because some sorts of allegation against the SCSO. For that reason,
what was the allegation she made against you?
Against my lord, your lordship, I have annexed the
Annex 3, page 21, my lord.
Yes. What
That
are
is the
allegations
statement of the
attached to-
victim, my lord. That
Yes.
is not a first occurrence. Previous that, my lord, he has also.
Yes.
He has created all this.
Read, what is the allegation? Let us understand.
I, Pushpalata Das, Assistant Civil Supply Officer, Balangir Municipal.
Come to the relevant part. Don't
My
read
lord,
it.
that is-
Five lines. Last 5 line, my lord.
Mr. Raja Ali, Chief Civil Supply Officer, Balangir, have no reason scolded me in front of all other CS, field executive present in the BC. Mr. Raja Ali, CCSO, became very personally and abused me in front of the CS field executive, threatened me their consequences. So and so, that has been created.
And the last 5 lines, my lord.
A lengthy FIR has been created.
Yes, last read it.
My lord, last 5 lines. Let me see that.
What are last?
Page 21, last 5.
21, na?
Right.
21, 22.
21, my.
That is the statement of the.
Really, ଆପଣ ଏମିତି କଥା ମତେ କହନ୍ତୁନି ଏଇ ଉପର
My lord, ସେ କହିଲେ ଘର ଲୋକ ବୁଝିବେ କି ଯେତେବେଳେ ତାପରେ my lord.
read it. What is the problem? That part you don't read. ତାପରେ ସେ ମତେ
For that reason, a committee has been constituted. वीडियो कॉन्फ्रेंसिंग होता सेटार मते समस्त सामने रे अलगा कथा कहले वीडियो कॉन्फ्रेंसिंग सरला पर सेटिंग देले ताकि वीडियो कॉन्फ्रेंसिंग मु गोटे जगह रहली समान गोटे जगह रहली
but these utterances, have you seen it?
My lord, for that reason he has complained before the collector and the secretary. They have constituted a board. Your lordship may state, I have annexed the entire person statement, those who are present at the scene of occurrence. That is page 24, 25, thereafter 26, 27.
Get me that judgment where what is the effect of the committee report,
My
which is
lord.
a statutorily constituted committee. If the report says something,
My lord.
whether on that basis a criminal case can be passed. Show me the judgment. Do you have?
That extent, my lord, 2 to 3 days time. Allow, I will produce.
That's the only issue.
That is the only and statement of the witnesses.
Don't say all the. This is the only point you
Only
have.
point
And you show me the judgment. if you have.
I'll show.
My lord,
What do you say?
investigation, my lord, going on. Let the charge sheet be. He may wait till the submission. of
That's
charge sheet.
another issue.
That may be taken into consideration.
I'll say that the investigating officer shall take into consideration the report.
Yes, ma'am.
Yes, my lord. You are
That's a better idea.
Yes, ma'am.
Right on. Petitioner has invoked the inherent jurisdiction of this court, seeking quashing of PS case number Bolangir town PS case number 404 of 2022 for alleged offence under section so and so at the instance of opposite party number 2. That the initiated in the instance of opposite party number 2. Investigation of the present case is still going on. Mr. Das, land counsel for the petitioner, has strongly relied upon the statutory committee
Right.
constituted under what is that act? Prevention of what is that act?
That is only
Workplace prevention. I'll tell you that act.
Right.
Sexual assault from the workplace of the woman.
Vishakha, after that Vishakha
Vishakha
judgment,
judgment.
statutory committee report dated, report dated
Report dated, my lord. 9/9/2022.
9/9/2022. He has contended that in the report, the committee has exonerated him. The report seems to be a lengthy report, taking lengthy report, and this lengthy report and the issue as to the effect of a report submitted by a statutory committee needs to be gone into. Since the investigation is still going on, the petitioner is given liberty to place the report before the investigating agency. If such report is placed, the investigating agency may take into consideration the same. This much I can say. I can't say that. I can't say that. Take into consideration with this liberty, with this observation, the petition is disposed of. Yes.
Disposed of. Obliged.
You give that report.
My
They
lord,
may
I'll
file
produce
a
that
closure
report.
report also.
It will suffice. Obliged.
12.
Item 12,
Yes, madam.
I challenge the rejection of my discharge petition under section 239 of CRPC.
Yes.
My lord.
Yes.
And my lord, if your lordship for a moment allow me to place some records, my lord, that is where I have applied under RTI Act, my lord, that my submission where records.
How can I rely upon the document you have obtained in RTI while deciding your charge?
The same
Charge has decided on the basis of the documents form part of the charge sheet. You may bring any document subsequently. Those things may be your defense. I can't rely upon those documents to satisfy you.
Only some where records are not available, where all records are pertaining to 1970 to 2000 were born. Then how my records are verified, my lord? How on which basis my records are verified? That I have submitted fake certificate, my lord.
You will ask this question to IO in the cross.
That IO may being biased to their completed investigation and charge sheet submitted against me.
Come to the charge sheet, madam. Let us see the charge sheet.
This is matter relating to submission of fake certificate. On that basis, my lord, charge sheet was submitted and discharge petition was rejected. He may urge this argument with the court below that some documents, if he has obtained some documents.
I have a judgment of this honorable court, my lord.
Show me if that judgment can help you.
That is where challenge is partly allowed by crossing that your lordship may last two paras are quite relevant, ma'am.
Yes. Read it out.
I have no other copy. I'm sorry, madam. No, that was misplaced somewhere, my lord.
What?
I have down.
This was misplaced.
No, that
Where is your copy?
No,
Why are you coming to the court with one copy?
No.
There are three persons.
I
He is there looking at you. I am also looking at you, and you need one copy.
Sorry, today I dropped it somewhere, my lord. I have prepared two copies, my lord.
Madam, properly do it properly.
I'm
See,
sorry,
these
madam.
are the cases, you know, unnecessary pending.
Somewhere.
What does it say?
Where no intention to commit such crimes.
How do I know intention is there or not?
Intention cannot be proved here.
Can't be proved. See, this may not help you.
I have also a judgment of Supreme Court also, where allegations are groundless. That I have to call.
Madam, the allegation in that case might be groundless, but in this case, all grounds are there. Because you have procured a fake certificate, utilize that for the service. And now what you are saying is on the RTI, I got some information, the certificate may be correct.
Certificate, the particular stream which I have produced, that BED, that if you lordship for a moment, if you lordship see page number.
You remove from the service also?
Yes, madam.
Yes.
Just a minute.
What was the job?
And that is
Teacher.
That is, if your lordship see page number 40, my lord.
40?
40.
Yes.
The relevant portion, may I please spell it?
Yes, yes.
The original tabulation register of all examination relating to the following professional subjects courses since inception are burnt in the fire incident, and that is, if you lordship say serial number 15 BD along with other streams, but all were burnt in this fire incident.
You have given in the Barampur University.
My lord. My only submission, how my certificates were verified, where no certificate, where no original certificates are there, they all were burnt in the fire incident.
Yes. Charge sheet, what does the charge sheet says?
Charge sheet, they have not mentioned any of these things,
My
that
lord,
the
that's
fire
it.
incident was
I'm-
happened.
I'm reading, my lord, that para second, my lord. That he has seized, IO has seized the fake BT certificate submitted by the accused person at the time of their appointment at BO office ASCA.
No, what she says is, during that period when the certificate was issued, the entire record is burnt.
My lord,
in the university.
that question he raised before the court below. Whether where he has got that obtained the certificate from the RTI.
And for that reason, I.
That he has to ask before the court.
The RTI only says that it was burnt. RTI doesn't say that it's fake or.
That will be decided at the time of trial, whether that period the certificate was born or not.
No, I am only thinking of one thing. See, he was a teacher. He lost the job. And this prosecution. He
Not
did
only
not
this
disproportionate to the.
Well, not only this person, other teachers are there. Other
How many
teachers are
teachers?
there.
How many teachers?
Well, they have a.
Three teachers.
Well, 3 numbers are there. 3 teachers are there. They have submitted against all FIR was lost.
But my.
Madam, what I
How
can
he
do
has
is I will expedite the trial. That's the best thing.
So Lordship may give me one more opportunity. Lordship may fix a short date. That day, after that.
Short date I can't fix, but see, you have taken time how many time I'll tell you? 1, 2, twice.
And discharge petition was rejected in the year
For
2020.
that reason, that is on the basis of this RTI documents, I had approached under.
RTI document, Madam, I try to appreciate one thing. RTI document you may have procured, but I can't take into consideration at this stage. These document can be used for the purpose of your defense. Today I can't take into consideration and decide. I can't accuse you like this.
Allowed me to make it necessary by Barampur University. That can be verified. That can be clarified.
I can't conduct a trial here. Why don't you understand?
Mini trial
Exactly,
can be
not a
conducted.
writ petition. I'll call Barampur people and everybody start asking whether right certificate or not.
Whether the mini
This
trial
can't
can be
go.
conducted here.
Completely valid.
What I can observe is you can raise all these points before trial court, and trial court should expedite the trial in the peculiarity of the case.
So the Lordship may give me any sort one more opportunity. Then you.
That I will pass the same order subsequently, because it is not permissible under law.
The Lordship, with this observation, your Lordship may dispose of them. Then.
That's what I'm saying. Give me the judgment. Give me that. Learned counsel for the petitioner has assailed the order dated 30th May 2023, passed by learned JMFC bracket T ASCA in GR case number 844 of 2019, whereby her application under section 239 CRPC for seeking discharge has been turned down. The allegation against the petitioner is next paragraph. Allegation against the petitioner in the FIR is so. C has obtained the RTI information from Barampur University. The RTI information reveals that the record pertaining to the year, which year?
1997.
1997 has been born.
1999 2003, all the documents relating to those streams were burnt.
All the documents relating to the stream in which the petitioner was studying has been burned. The learned counsel for the petitioner therefore submits that the police has not verified the fact as to how they have arrived at the conclusion that the certificate has been fake. Certificate has been fake. Fake certificate. Okay. She has relied upon judgment of the court reported in 2013, bracket 1 OLR 403. Surendra Kumar Mishra versus State of Orissa. Orissa. Which paragraph?
That is last but not the least, that is paragraph 10 and 11 is quite relevant. But sorry, paragraph 10 and 12.
Paragraph 10. Paragraph 10. Please. Paragraph 10, please. Since the petitioner's entire case hinges upon the documents she has obtained through RTI, I'm afraid the same could be relied upon at this stage to decide the present case. The documents which the petitioner has procured through RTI may be utilized for her defense. And at this stage for deciding at the stage of framing of charges, the documents cannot be relied upon. Therefore, I'm not inclined to entertain this petition. However, liberty is granted to the petitioner to raise all these points, and with the help of the document he has obtained through RTI at the appropriate stage of the trial. And trial court is directed to see that trial court is directed to do well to see that the trial is concluded as expeditiously as possible. With this observation, the petition is disposed of. Yes.
Correct.
Next. 1-3. Yes.
Petitioner is the registered owner of a Mahindra Bolero pickup van.
Sorry?
Petitioner is the registered owner of a Mahindra pickup Bolero van.
Yes.
His vehicle has been seized in connection with the section 7 and 11 of the Prevention of Cruelty to Animal Act, and the rules 5 of
it is released with the direction to
release with
cash deposit.
Cash deposit. Instead of cash
That is
deposit,
the, as per my lord, the Animal Welfare Board
regulation.
that he has fixed 200 rupees per cattle.
Right.
So on that basis, a calculation was made and he has been directed to deposit.
I have a judgment to that. I have a judgment of mine own judgment. Once assessment is made, you have to make the payment.
My submission, instead of cash deposit in full amount.
No, the cash is required to feed the cattle.
But
the cash is only asked for you to feed the cattle.
But by imposing such cash deposit, it amounts to denial of justice. That not unworkable.
That's right, but this is the mandate of law what to do.
This is unworkable order.
You move application for variation of that order.
Variation, once the court passed order.
I give that liberty. You can ask for reduction. But part of the payment you have to make.
Part of the payment in cash and part of any other security.
Security is not
order is very clear, man.
The order is clear. I am not saying order is not clear. I am only saying that variation, but this order is unworkable. Imposing such a huge condition, payment of a huge amount, more than the value.
No, this is a truck, na?
Bolero van.
Bolero.
For the 3,000 or 200. Around more
what is the value of the vehicle?
Value at best 10 lakhs, 7 lakhs, 10 lakhs old vehicle. For the 3,200, it's more than 7 lakhs.
Under the law,
petitioner is agreed by the order dated 16/2/2024 passed by the district and sessions Judge Bhadrak in criminal revision number 24 of 2023.
Order passed by the SDM Bhadrak, which country?
The application, the order passed by the court of which court? SDM Bhadrak in Miss Case number 186 of 2023 has been upheld. The court of SDJM Bhadrak, while disposing of the application of the petitioner for release of the vehicle, offending vehicle, namely the Bolero van number OD -22L of 22L-7881 has directed the petitioner to deposit
1,12,000.
1,12,000
within till 2023 and another 3,200 per day till the date of release.
2000 and till where is that? Till
36/6/2023
and thereafter
3,200 per day.
3,200 per day. That part I'll set aside. This part you pay. At least the petitioner is next part. Petitioner is agreed by the order by the said order passed in his application under section 457 CRPC. I am not inclined to entertain this application at this stage. The contention of the petitioner, that counsel for the petitioner, is that this order is improbable and impractical and not executable because the cost so imposed while allowing the application under 457 CRPC exceeds the would exceed the cost of the vehicle itself, cost of the vehicle itself. In that view of the matter, I am inclined to modify the said order. The petitioner is directed to deposit a total sum of rupees 1,12,030 rupees, 1,12,000 rupees in toto, and furnish indemnity bond, suitable indemnity bond to that effect. While releasing the vehicle subject. With this observation, the petition is yes.
Well, that amount may be increased because it is order of 36/2023. In the meantime,
50 कर देंगे, 50, 150 कर,
right,
150 कर, 150, yes.
14. Please, minutes. Minutes here under challenge is the order rejecting my recall petition under section 311 of the Code, Your Lordships. The facts are as such, minutes.
Sorry?
The facts are such, minutes.
Your application under
311 has been rejected, minutes. To recall of witness that has been rejected. Lord, here the petitioner is complainant preferred to 138 NI Act offense complaints, minutes. Those two 1cc complaints were registered, Your Lordships. Two 1cc complaint pertained to dishonor of two checks, minutes. One of 1 lakh and other of 2,60,000 respectively. Lord, what happened is inadvertently those two demand notices have been interchanged.
Okay.
In the complaint cases. So far as those averments are concerned, description of those exhibits are noted perfectly and correctly, Milods.
But the notices, demand notices,
exhibits have been interchanged.
Okay.
So hence, my lord, on cross-examination, that has been learnt by the counsel for the complainant, and thereby recall petition was preferred.
Rejected.
And recall petition has been rejected.
Issue notice, issue notice to because it's arising out of 138. I'll have to issue notice.
Yes, notice was issued, my lords, on the
notice was issued.
Yes, that has also been rendered sufficient.
Okay. Then I'll allow. I'll have to allow.
Gotcha.
Right on. Service complete. देखो तुम. Right on. Notice was issued to opposite party number 2 by order dated 16/5/2024. The service of the notice on the opposite party is sufficient. Nobody entered appearance on behalf of opposite party. Then comes the petitioner is agreed by the order dated 4/4/2024. There are two petitions.
One, my lords. Only one recall application.
Okay, interchange means one is wrong.
Yes, the other.
Other is paid. Order dated 4/4/2024, whereby his application under section 311 CRPC for recalling PW1 for cross-examination has been turned down. Learned counsel Mr. Das, learned counsel for the petitioner, submits that two checks issued by the opposite party was dishonored. He issued two different demand notice under section statutory demand notice under section 138 NIA. But while filing the complaint case, the demand notices were interchanged and wrongly filed in the present case, in the present 1 CC case number
40 of
40 of
22 minutes.
40 of 2022. 1 CC case 40 of 2020. When while cross-examining the witness, this aspect has been discovered by him. Therefore, he moved an application under section 311 CRPC for recalling of the witness. The trial court, without appreciating the aforementioned facts, has rejected the application. Hence, he is aggrieved. Regarding head to the aforementioned, I am inclined to allow the application. Accordingly, the order dated 4/4/2024 is set aside, passed by so and so has been is set aside, and the petitioner is given one more opportunity, a single opportunity to cross-examine the PW1. Trial court is directed to summon the witness, said witness, and fixed a date of hearing for the purpose of cross-examination. On the date fixed to be fixed by the trial court, the petitioner should cross-examine the said witness without seeking unnecessary adjournment. With this,
I'm citing one judgment.
what I have allowed. What?
Wait.
Yes, allowed. Yes.
16.
You want me to write? I'll write it.
Lordships, because the ground taken is that it is a patching of the lacuna which is impermissible. Addressing that,
It's all right. I have recorded sufficiently. Yes.
16.
Yes, 16. What is this? What is FIR? Yes, madam.
Item number 16.
Yes, madam.
My lord, on behalf of Mr. Suryanarayan Bisar, personal difficulty. Next week time.
No. What personal difficulty? What? See, you are asking for investigation is over.
My lord, her file has been misplaced in our chamber.
Investigation is over.
Next week time, my lord.
For 20 is there, that has been proved that his bank deposit is there. It was there. But he is asking for the cost of the person.
No, what are the allegations? Let us read the allegation. Read the allegations.
Johnson, aged about 41 years. Working at South.
The relevant part.
Such. No, that amount part is there, no. That Sambit
16 lakhs 35,000.
16 lakhs 75,000. He has taken, from which 38 lakhs 35,000 taken through bank transfer of his account, and 80,000 cash, which my husband to transfer the person's named Anil Kumar Patra of Bhubaneswar, and he withdraw and gave cash to the Sambit Samuel as per the Sambit Samuel's instruction. We also gave the order of the Calcutta High Court and other documents like my husband's medical documents to produce the same before the court. But he did not do so and asked for more money, but we were unable, as we have borrowed huge from our relatives to fulfill his demand. And now we are no source to fulfill.
He is an advocate.
Yes.
Taken in the name, taken the money in the name of honorable judge of this court.
In other way, is taken the, I will give the order to you.
Just see the part of.
Yes.
He has taken gold chain and gold bracelet in the name of one of the honorable judge whose name is written here.
Bank transfer is also, for that only I was saying that bank transfer is there, all those documents is there.
Twice. He is a lawyer. What is happening? Just read the allegations. Read the allegation. And you are, madam, you want passing of this.
False allegation, my lord.
False are right, but see, the complainant has given very meticulous information. 8 lakhs you have taken first. Thereafter, you have not got the application listed. Then you say that the judge is asking bracelet and what is gold chain, and the judge name is also written.
Yes, but that only I was saying that let him appear and he should say.
See, I will not only dismiss this with heavy cause, and I think I will send this to be inquired by the Bar Council.
My lord, day after tomorrow.
No day after, nothing. These kind of lawyers should not be encouraged. See, do you realize the name of the honorable judge is so respectable?
My lord, all are false allegations.
The false are not the investigating agency will see. The allegations are so serious. I'll write a judgment reserve. I'll write a judgment on this. You can't do all these things. We said that judges are being told every minute without their knowledge. This is one such case.
I said what is defense, what he is saying that.
What kind of defense you have? See, the poor lady who is given the this thing, she is giving very detailed and money is transferred in the bank account.
Yes.
What defense you would have? And if you want to say anything, you give in writing. I am reserving the judgment. Yes, next.
20.
You also give in writing, so that there should be stern message to go. We will not leave it like that.
May I please, Lordship? May I please?
20.
20.
Yes.
My lord, the petitioners are the daughter-in-law and nephew of the informant opposite partner 2. My lord, I have challenged daughter-in-law and nephew, son of the daughter-in-law of the informant, Lordship.
Yes.
Lordship, I have challenged the order of cognizance on page 16. This has been taken in a separate complaint case arising out of a protest petition. What is the case, Lordship? Initially, the FIR under Annexure 1, Annexure 2 was initiated. There was no specific allegation against the petitioners. The charge sheet was submitted.
Come to the protest petition.
Yes.
Come to the protest.
Lordship, Yes, for Lordship, kindly come to page 20.
What is your name?
Page 20. My name is Joyashree Bal,
Bal and
Saurabh Patra.
Saurabh Patra. Come to 4 then.
Yes, Lordship.
What are the allegations?
Page 29B, capital B, Lordship.
Joyashree and Saurabh. Okay.
That after marriage, the complainant went to the house of her husband and remained with her husband, leading to a conjugal life with her husband after 10 to 20.
Where are you reading, sir?
Lordship, page 29, capital B, paragraph.
Capital B paragraph. Okay. Okay. Yes. Remain with her husband, leading to a conjugal life.
Conjugal life, marriage, the father-in-law, Proflo Kumar Bal, mother-in-law, Kavita Bal, elder brother-in-law, Dedushura, namely Sandeep Kumar Bal, elder sister-in-law, Jaya, namely Priyanka Bal, and sister-in-law, Nananda, namely Joyashree Bal, Patra, with a common intention, instructed the husband of the complainant to demand a further cash of 2 lakhs. This is the allegation.
Dowry.
This is the allegation in the affair, and this is the allegation in the protest petition.
I'll issue notice. What is this? Husband and the family member might have asked. The nephew and all instructed the husband, my husband, to ask for 2 lakh rupees as a dowry.
Annexure 6 last week, the person is prosecuting study in outside of Orissa. I have given the certificate at the relevant point of time. The petition number 2.
Yes. Issue notice to the opposite party number 2, returnable something. The initially FIR was registered against the petitioner on the other family member. However, after the investigation, closure report has been filed by the police. Subsequent thereto, the opposite party number 2 has filed a protest petition. Inter alia making the following allegation. B, page 29, B. B, capital B. The allegation in the protest petition and subsequent inquiry reveals that the petitioners have instigated the husband of the informant to demand dowry, except that there is no other allegation. Yeah, no other allegation against the present petitioner. Issue notice to opposite party number 2, written also in the, are you protected?
Yes, yes, I'm on 205 or stay the further question.
Yes. They have, then other accused persons are there?
No, it's a separate complaint case.
Acha, till the next date of hearing, the further proceeding in ICC case number so and so, state, huh? Okay.
22.
And subject to the petitioner filing the requisites within 2 days.
Oblation.
If the appropriate requisites are not filed, the interim order passed today shall be automatically vacated.
By Monday or 2 days?
By Monday.
By Monday.
At least you will file requisites.
Yes. I will file, so that cannot.
Yes.
Item 22, revision is maintainable, madam. I may be permitted to convert it to revision.
Then counsel for the petitioner, this is against charge?
My lord.
Then counsel for the petitioner submits that the present petition has been filed against the order framing charges where revision should lie. Therefore, he makes an oral prayer for converting the present petition to that of a revision.
Second connected matter is against the cognizance. That is infraction. Your lordship accordingly dispose of this.
Revision. The registry is directed to renumber or nomenclature and number the present petition and list it before the appropriate bench, subject to the approval of Honorable Chief Justice. Second matter, in view of the fact, in view of this petition is the cognizance order dated so and so, and subsequent thereto charges have been framed, so therefore the present petition will become infractious and dismissed as infractious. Yes. Yes.
23.
Yes, sir.
Quashing of very initiation of proceeding.
What is the stage?
Investigation is going on. The person who was main culprit, he has been protected, and also other persons, they have been protected.
So wait, you don't have protection.
No. Other persons, they have been granted anticipatory bail also.
You also apply for anticipatory, you will get it. Who stops you? Why 482 investigation is going on? And the FIR was registered only on in the March 2024.
Injuries are simple. The person is the main accused is
all right, you will get 307.
Saubhagya Malik. Saubhagya Malik is the main culprit. Your lordship can see the FIR.
I'll record everything and dispose it up, and you go and apply. And I'll give you liberty to also approach this court if cause of action still survives after filing.
Otherwise, your lordship may kindly be protected. I will surrender before the learning court below. It will suffice the entire thing.
Specific about that is there, my lord. Supati Malik, my lord.
Oh, he's not on merit, he's not saying anything.
My lord.
Because the other co-accused persons have already been granted
anticipatory bail, my lord.
He has not approached the court so far.
My lord.
And he wants to withdraw it to appear before court. Until then, I'll protect. Right. Although the petitioner has challenged, petitioner has assailed the initiation of criminal prosecution against him and seeking quashing of the FIR. Which FIR is this? Denkanal town PS case number 175 of 2024. But he submits that at this stage he will not press this petition and reserve his liberty to approach at the appropriate stage. Mr. Das, land counsel for the petitioner further submits that the other co-accused persons have already been enlarged on anticipatory. Therefore, he would, on instruction, he says that he would appear before the court on or before 15th of October. 15th of October 2024 and seek remedy available to him under law. Till then, no coercive action shall be taken against him. Don't appear. It's like interim anticipatory bail. If I don't pass that order, again he'll file another application and burden on the court again. And appear, that's better.
I will not disclose.
Yes.
47.
47. See, before lunch, in all these matters, everybody was short time. You have seen. And I said that I will not adjourn and everybody argued.
My lord, item number 47, my lord.
47.
37.
Yes.
37.
37.
You not allowed the but subject so he has to give an earlier FIR, my lord. Complete earlier FIR. But the victim, is about 24 years. She stated that earlier.
37.
My lord. The lord, she passed the order, but ask my friend to give
To
the.
submit the earlier FIR, but no FIR has been lodged. The PLA case has been lodged, which has been ended in compromise.
So me, I forgot it now. You tell me what.
That my lord, 376 to an FIR was lodged. The incident took place 2017 to 19. In 2023, on the previous day of marriage, this FIR is lodged on the ground that 2017 to 19, I have relationship with the present petitioners, and but he denied to marry.
Short ones is to
Read. I forgot it.
ये 14 ମାଉସୀ ଘର
Hmm?
ମ୍ୟାରେଜ
Yes,
14 ମସିହା
ହଁ।
ମାଉସୀ ଘର ମ୍ୟାରେଜରେ ଗୋଟେ ପୁଅ ଲକ୍ଷ୍ମଣ ପାଙ୍ଗିକୁ ଦେଖା ହୋଇଥିଲା ପିଟିସନର ଦେଖା ହୋଇଥିଲା ଆମେ ଦୁହେଁକୁ ଭଲ ପାଇଲୁ ସେ ମୋ ସହ ବାହା ହେବ ବୋଲି ଶାରୀରିକ
affidavit because he has 10 numbers of antecedent. Now he's praying that interim application he has also not filed.
Have you
Interim
filed
application has been filed, your lordship.
Yes,
That is
yes.
IN number
995.
995.
The
What-
copy there.
Where are the medical records?
And in the TI period also he was identified. My lord. And one knife and pistol was seized from the co-accused persons.
The chest pain and all.
Yes, and doctor also advised for ECG, my lord.
Huh? Advice.
Doctor advised for ECG.
These are-
Also attached the copy.
My lord, this is not certificate only. He has given a document
Initially, the doctor
that
said that was
requisition for ECG. The requisition was made for
whatever
ECG.
available, my lord, I have to be annexed.
See, do one thing. I am giving you liberty to move interim application before the court below. Regular bail is not possible because the TI period you have been identified. 10 number of cases are there. And get good document for the purpose of interim bail. You may get.
My lord, his disease is, my lord, of chest pain. Pantop was prescribed. Pantop was prescribed.
Gastric
They
problem.
also ECG also
Gastric problem.
advice for ECG also, my lord. And the lady
Gastric
is
problem
alone.
only.
The lady is alone in her house. That is why, my lord.
Everybody is taking this pantaplos.
But initially, what they
So this is
go to the doctor and doctor suggested.
you may have a good case, but get good document. You are procuring document from the doctor. Get a better document. In any case, you have to procure.
Let it lie over, my lord. Let it lie over.
Why pentapose and all?
My lord, initially.
Get a better one. I am giving an opportunity to procure better document. Okay.
Arjun, I prefer
The
Arjun, my lord.
petitioner is an accused in so case, and allegation against the petitioner is so and so.
My lord, Arjun, kindly
And,
Arjun, I have
no,
to file the
no
better.
adjournment. See, in the present case, TI period, in the TI period also, the petitioner has been identified. There are 10 number of antecedents against the petitioner. Therefore, I am not inclined to enlarge the petitioner on bail at this stage. The petitioner has moved an application under application for interim bail on the ground that his mother is seriously ill. However, he has not placed the satisfactory medical document to support the contention. I'm not inclined to entertain this application, interim application as well. However, liberty is granted to the petitioner to move to the trial court for regular bail, as well as he can move an application for interim bail on the health ground of his mother. If such application is moved on the basis of the after verification of the health of after due verification, the trial court may consider the interim bail for the petitioner. With this liberty, the petition is disposed of. Get proper document and file before the trial.
My lord, 13 your lordship directed whether the TI period was conducted or not. Then, my lord, this is the document that is 180/24,
Right,
August
I
1st and
understand.
31st. He has not placed on that.
Once you grant bail, he will never come.
No, 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 one.
Yes, yes.
A local resident. Lord.
Anyway, yes, next. But still I gave you liberty. You can procure good
Please, Your
document
Lordship.
and go.
Permitted to withdraw. Item
Yes,
612.
permitted to withdraw. Yes.
Obligation.
Yes,
63. My lord, may I, your lordship kindness.
yes, sir.
Document your lordship. My lord, I have already started my lord.
Now you.
Here, my lord. The 164 your lordship 93.
Your bail application is 2 pages. And paper, this much paper he is giving. Now read now and
Now,
give
my
it.
lord, I have received.
2 pages bail application. Saying nothing. Anyway,
Right.
you are in custody since?
Since my lord,
22/1.
22/1/24.
24.
Yes, tell me the allegation.
3762 and 506.
Have you
That's
gone through it?
Yes, yes, my lord.
Yes, tell me.
Only, my lord, 3 to 4 lines, my lord. 164 statement.
Yes.
Relevant part, my lord. The victim is a married lady having 2 children. And ଥରେ ମୋ ସ୍ୱାମୀ ଘରେ ନଥିଲେ, ସେ ପିଲା ସୁରେଶ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଗୋଟେ ସ୍ପ୍ରାଇଟ୍ ଥଣ୍ଡା ପାନୀୟ ବୋତଲ ନେଇ ମତେ ଘରକୁ ଆସିଲା। ସେ ମତେ ସେଇ ଥଣ୍ଡା ପିଇବାକୁ କହିଲା। ମୁଁ ବିଶ୍ୱାସରେ ଥଣ୍ଡା ପିଇଦେଲି। ସବୁବେଳେ ସେ ଘରକୁ ଆସୁଛି ବୋଲି ମୁଁ ଥଣ୍ଡା ପିଇ ସାରିବା ପରେ ମୋର ଚେତା ହରେଇଲି। ହଲଚଲ ଦେହ ଯାକ ମୋର ହେଇପାରିଲାନି। ମୁଁ ସେ ମୋର ବେହୋସ ହେବାର ସୁଯୋଗ ନେଇ ମୋ ସହିତ ଖରାପ କାମ କଲା।
Medical?
Medical, my lord, there is no
Nothing.
No, my lord, no sign.
Nothing.
Victim?
Medical was conducted on 23/1/24.
Incident?
21/1/24, after 2 days.
What is the blood report?
My lord?
I have folded, my lord. Medical report, I have folded nothing, my lord.
Where is the blood report?
My lord, medical report.
Fold करते हैं, सेटा सब लिखा है.
No, blood report is not there. They were neighbors or what?
Again, these are not same group, same age.
Neighbor, he also he is regularly coming to the victim's house, and he also help in some
Acquaintances.
acquaintances there.
ଆମେ ନଥିଲା ବେଳେ ବି ଜିନିଷ ପତ୍ର ଆଣିକି ଆସେ କରିକି ଜାଣିଲ.
Only allegation that there is some videos that the petitioner always threatening that if you will come, you will not keep relationship with me, then I will viral the videos. Well, video is not viral.
That is not there.
They must be.
It is a consensual matter, that is 2 children.
The petitioner is accused in FIR number 2, so allegation against the petitioner is such. During the investigation, the statement of the victim under section 164 CRPC has been recorded. Where is that statement? She has inter alia stated that the petitioner one day entered in his house and gave some cold drinks to drink. After drinking the cold drinks, she lost his conscience and taking advantage of the same, petitioner has sexually assaulted her. She was subjected to medical test. The medical test, the doctor has opined that there is no sign and symptom of recent sexual intercourse. The petitioner is the victim with 25 years of age and having 2 children. It has come on record that the petitioner and the petitioner has been visiting the house of the victim regularly. They were neighbors. They were neighbors. The petitioner is in custody since 22/1/2024. Regarding into the nature of allegation and the medical report of the victim, I'm inclined to in the advocacy on bail. Yes. Huh? क्या करोगे देख लो। Yes. How many matters remain? Huh? Bail matter कब करूँगा? Bail matter कब? 1 minute, I'm not taking up mentioning. Yes, next.
68.
Which matter is specially fees?
Item 120.
One? Yeah. How? Yes, how much time will you take?
5 minutes.
Then I'll take at 4 o'clock. Let me complete the bail matters first. Yes.
68.
68. 68, yes.
Made, please, Your Lordship.
Mm.
Well, in this case, the petitioner is in custody since 4/12/2023.
Yes.
Allegations under section 498A, 304B, and other allied offences.
304B?
My lord.
498A.
498A and 4 DP Act.
No, 306.
306 is also there.
You
306.
tell me that.
My lord.
Yes. Yes.
Well, the allegation is that the wife of the present petitioner consumed poison because of repeated insistence for dowry.
You have CD?
Yes.
Yes.
But the order dated 16/4/2021, Lordship, it has been reflected that charge sheet is yet to be framed against the accused.
Charge sheet has already been filed.
When?
Charge, my lord.
Charge is yet to.
Oh, charge,
Well.
get it. You tell me the allegation. 306, consume poison.
My lord.
See, primary report is the burning injury there.
Burning injury.
No, my lord, she consumed poison.
So it is there, PM with me.
I have the charge sheet, and in charge sheet it is about poison, consumption of poison.
Check it up.
Yes, burning.
Burn injury.
Yes. Burn injury.
Are you sure that you are reading some same charge sheet
Yes.
of this case?
Yes.
There is written that
Tarjan Behra क्या है? Tarjan Behra.
not finding or antimatum nature and produced due to oral intakes of intoxic irritant substances. However, to ascertain the exact nature of the substance between visceral preserve.
No, it's not burning, intoxication. Yes. Where is the burning thing?
The above mentioned burn injury is antimatum.
Burn injury is there.
Yes.
Burn injuries inside the. I believe.
There is superficial burn injury, which was in the right list. But PM report there is intoxic irritant substance there.
See, read the eyewitness, anybody?
Burn injury is some part of the when the image
Is there any allegation of
no
burning?
Intoxicant substance.
Allegation is
No, my lord.
allegation is not
No
there.
allegation.
And read whether the poison is consumed by herself or administered by this man.
I have the 161 statement of the father of the deceased. May I please?
Read it.
My lord. ଗତ 2 ବର୍ଷ ବିବାହର କିଛି ଦିନ ପରଠାରୁ ତାର୍ଜନ ବେହେରା ମୋ ଝିଅକୁ ସବୁଦିନ ଯୌତୁକ ଆଣେ କହି ମୋ ଝିଅ ସହିତ ଗଣ୍ଡଗୋଳ କରୁଥିଲା। And on such and such day, Tarjan Behra mate phone kari कहले तम झियो संतोषिनी विष खाइछि एथि जोगु मु ब्रह्मपुर मेडिकल को चिकित्सा पे आनिछि वर्तमान
Then the accused has said that your daughter is no,
Yes,
you
sir.
show me any evidence.
This is the
that,
161 statement.
That's any evidence that the girl herself has taken the poison?
No. Poison part is not there.
Read the 161 statement of other witnesses. I think he is not prepared. Let it be after 1 week. After 1 week. You read.
See, I am reading this one.
I read properly. Read. I can't waste beyond 5 minutes. I will not give 69.
आज 3 बार 2023 करो जोड़ा थाना
69. Next item. Yes. 69.
Grateful. May I please, Your Lord?
Yes.
CD is required.
CD not there. CD. Formal CD.
Sorry.
Yes.
So that can be.
He'll give it. Yes. 70.
Please do not see.
Yes. Yes, sir.
And last occasion, my lord, direct to my lord friend, and obtain the case diary as well as.
Case diary is there.
Yes.
Have you read it?
Yes.
Have you read it or you'll read it now?
It is, I have written all these things.
If you have you read it, then I'll take it up. Otherwise, tomorrow, day after.
Day after
Huh?
It is there. All the things I have marked it.
Yes.
Allegation under section 302-506.
302.
My lord.
Yes. What are the allegations? Custody since?
Since 31/7/2023.
31/7/23. Okay.
23.
Yes.
Allegation is that, my lord, the informant was working as a
You are Krishna Chandra Pradhan.
Krishna Chandra
Yes.
Pradhan.
What are the allegations?
Yes, my lord. The allegation is that, my lord, the informant was working as a laborer under the contractor by name Narasingh.
What is the overtake?
My lord.
What is the overtake attributed to you?
My lord.
They both brother, they.
No, the present petition has no role. The another brother, Torni Sena, is the main accused. He has assaulted the deceased.
What have you done?
My lord.
What have you done?
Well, I was standing in front of the camp.
Oh, read that one. Eyewitness. Eyewitness.
Yes, Lord. Eyewitness.
Read it. Read it. Who is eyewitness?
ନିରପରାଧ ମାନେ ଜଣେ ଅପରେଟର କରୁଥିଲେ ତା ଗତକାଲି 29/7/2023 ବର୍ଷା ଯୋଗୁଁ କାମ ବନ୍ଦ ଥିଲା ସମସ୍ତ କର୍ମଚାରୀ ମାନେ କ୍ୟାମ୍ପ ଘରେ ରହୁଥିଲେ ଦିନ ପ୍ରାୟ 12ଟା ଘଣ୍ଟା ସମୟ ଆମେ ସମସ୍ତେ ଖାଇବା ପାଇଁ କ୍ୟାମ୍ପ ଘରେ ଶିବବାଡି ଆସିଥିଲୁ କିନ୍ତୁ ନିରୁପାଲ ମହାତୁ କିଛି ଜିନିଷ ଧରି ତାର ଗାଡିରୁ ବାହାର କରି ଫାଷ୍ଟ ଏଡ୍ ବକ୍ସ ଧରି ନିକଟରେ ଥିବା ତରସେନ୍ସ ପ୍ରଧାନଙ୍କ ଘରକୁ ଗଲା ତାପରେ ସେଠାରେ କିଛି ସମୟ ରହିବା ପରେ ଧାଇଁ ଧାଇଁ ଆମ କ୍ୟାମ୍ପ ଆଡକୁ ଆସିଲା ଆମେ କଣ ହେଲା ବୋଲି ତାକୁ ହିନ୍ଦୀରେ ପଚାରିଲୁ କିନ୍ତୁ ସେ କିଛି କହିଲା ନାହିଁ କ୍ୟାମ୍ପରେ ସେ ଖାଇସାରି ଏଣୁ ତେଣୁ ତାର ବ୍ୟାଗରୁ କିଛି ଜିନିଷ କାଢି ରଖିଲା ସେ ପ୍ରଥମେ ବଖରାରେ ଯାଇ ଶୋଇଥିଲା ଆମେ ଯିଏ ଯାହାର ଖାଇ ସାରି ନିଜ କ୍ୟାମ୍ପକୁ ଫେରିଲୁ ସନ୍ଧ୍ୟା ପ୍ରାୟ 5:30 5:00 ସମୟ ବେଳକୁ ଆମ କ୍ୟାମ୍ପରୁ ମୋ ପାଖକୁ ଫୋନ ଆସିଲା ଯେ ତରୁଣୀ ସେନ ପ୍ରଧାନ ଓ ତାର ଭାଇ କୃଷ୍ଣଚନ୍ଦ୍ର ପ୍ରଧାନ ପିଟିସନର ଆମ କ୍ୟାମ୍ପ ଘରକୁ ଆସି ଆରଜେକ୍ସ ଅପରେଟର ନିରୁପାଳ ମହାତୁକୁ ଘରୁ ଟାଣି ନେଇ ରାସ୍ତା ପରେ ପକାଇ ମାଡ଼ ମାରୁଛନ୍ତି ଆମେ ସେମାନଙ୍କୁ ପଚାରିଲେ ସେମାନେ କିଛି କହୁନାହାନ୍ତି ଆମକୁ ଏଇ ଗାଁ ଛାଡି ପଳାଇ ଯିବାକୁ ଧମକ ଦଉଛନ୍ତି
Direct allegation against you.
That allegation against the Torni Sena.
Huh?
Against the Torni Sena.
Both of you, both the names.
No, Torni Sena.
Next, another witness. Read another eyewitness. That part.
Torni Sena assaulted by means
ମୋ ନାଁ ଜଗବନ୍ଧୁ ନାୟକ ଓରଫ କାଳିଆ ବୟସ 25 ସେମ୍ ଥିଙ୍ଗସ୍ he said 5:30 ବେଳକୁ ସେମ୍ ଥିଙ୍ଗସ୍ yes
That part read it.
5:30 ବେଳକୁ ଆମ କ୍ୟାମ୍ପରୁ ମୋ ପାଖକୁ ଫୋନ ଆସିଲେ ଯେ କିରଣୀ ସେନ ପ୍ରଧାନ ଓ ତାର ଭାଇ କୃଷ୍ଣଚନ୍ଦ୍ର ପ୍ରଧାନ ଆମ କ୍ୟାମ୍ପ ଘରକୁ ଆସି ଆରଜେଏକ୍ସ ଅପରେଟର ନିରୁପାଳ ମହାତୁକୁ ଘରୁ ଟାଣି ନେଇ ରାସ୍ତାରେ ପକାଇଲେ
all statements are copy paste statement. But
Then all of them have said that you, along with your brother, has
similar type of
pulled up for the deceased and beaten up.
The charge sheet clearly says that at the time of entering into the camp, when the present petitioner and his brother threatened to the informant along with the deceased, all are decamped. All are decamped from the place.
Yes.
And no eyewitnesses. When they returned, they saw that deceased was laying.
Let the witnesses be examined. Right on. Petitioner is agreed by the order dated. Order dated.
Trial has not yet commenced. Trial has not yet commenced.
Yes. Therefore, I'm saying 8/1/2024. Charge sheet in this case has been filed on 27/11/2023. The perimeter of the charge sheet indicates that there are how many eyewitnesses? There are
4 eyewitnesses.
There are 4 eyewitnesses, those who have directly make allegation against the petitioner and the principal accused.
Pardon,
And the co-accused.
All are hearsay evidence.
Co-accused. I'm not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea before the trial court after the examination of the eyewitnesses. since the petitioner has been in custody since 31/7/2023, the trial court is directed to do well to see that all the principal high witnesses are examined, giving preference over the formal witnesses. With this liberty, the petitioner is disposed of. Next.
71.
Yes.
May I please? Say submit order 302, my lord.
7172 CD is required.
71/72 CD.
Date.
CD has not been received. Yes. 73.
May it please, your lordship.
Date may be, lordship.
May it please, your lordship. And offense under section 302 of IPC, my lord. The period of custody since 7 December 2022.
7
December 2022. 22. 7th December 22. And the prosecution allegation against
CD is there?
Yes.
Yes.
My lord, the prosecution allegation against the petitioner is that on the alleged day of occurrence, the present petitioner had asked the deceased to accompany him to plow his field. But after plowing his field while the deceased was resting under a tree, the petitioner killed him. That is the allegation, my lord. The evidence is there are no eyewitnesses to the occurrence. There are no direct evidence. The evidences are circumstantial. There are two circumstances against the present petitioner. There are some extrajudicial confessions, and the second circumstance is the confession under section 27 of Evidence Act. And with the section
extrajudicial confession before?
There were two other villagers, my lord. Two other. My lord, the section 27 Evidence Act, the witnesses in the section 27, they have been examined.
They have not supported.
They have not supported the case. Also, the extrajudicial confession before the persons, they have also been examined. They have not supported the case.
Then what is there?
164 there also. He has confessed after drinking. He has confessed
the
the evidence.
see, two things cited against him.
Yes.
One is extrajudicial confession and 27.
Yes.
The witnesses have not supported
My lord,
either of these two.
I have annexed the depositions also.
Then what else you have?
Deposition you have given. Deposition copy.
No, annexed the depositions.
Have you gone through these?
Yes, lordship. Here 164 statement of lordship.
Forget about 164.
Now, there he has said that he has in
164 is extrajudicial confession.
Yes.
And same witnesses have already been examined.
Yes.
In the court. He has not supported. Who is that 164? Whose 164 was recorded? Name?
Sachidananda Singh.
Sadananda Singh.
Show me his evidence.
PW2.
Show me his evidence.
PW2, page number
PW?
2, page number 18. Sadananda Singh.
PW2, 18. Yes. Sadananda Singh. Yes. Read it.
I know the informant Urbasi Singh. I know the accused Kalia at
Read para 2.
Para 2, my lord. It is not a fact that on 7/12/22 I have stated before the police that 6/12/22 there was a feast at our house. In that feast, the accused disclosed before me that he had killed Mangal Singh by beating him with a lathi. It is not a fact that the accused confessed before police in my presence that he had killed Mughal and hid the lathi under a bush inside the jungle, and that on his detection the lathi was seized by the police in my presence and seizure list was prepared. This is the said seizure list, marked as so, and my signature thereon marked as so. Cross-examination, I had put my signature on a plain paper as per the direction of police.
Nothing. Next, another,
my lord, that is
PW.
PW6, my lord.
Sankar.
PW6, page number 24. He's a section 27 Evidence Act witness.
Yes. 27.
My lord.
Yes. Next.
I know the informant of this case. I know the accused in the dock. I know the deceased Sushant Singh. He's dead since 1 year. I do not know how he died. Cross-examination. I am examined by the police in connection to this case, and
There's nothing. What do you want to say? There is nothing. He
himself confessed the things before the.
He himself confessed before two villagers. That is extrajudicial confession.
Yes.
Both the villagers came to the court and they said that he has not done it.
27 also is confessed.
27 witnesses also not supported your case. What else there? Why should he be then custody? Right? Petitioner is accused in so and so. The allegation against the petitioner. There is no direct eyewitness in the present case. Against the petitioner, the extrajudicial confession alleged to have been made by him before two villagers has been cited against him. Apart from the recovery effected under section 27 of evidencing. The two villages before whom the extrajudicial confession alleged to have been made have been, although examined under, the statement of the two witnesses before whom the extrajudicial confession has been made was recorded under 164 CRPC. And subsequently, they were examined in the court. Both the witnesses have resigned from their earlier statement, as a result of which they were declared hostile. Insofar as the seizure witness is concerned, he was examined as PW6, who has also not supported the case of the prosecution.
Two PW2 and PW6 both are seizure.
PW2 and PW6, both of them have not supported the prosecution. Therefore, so far there is no evidence that so far the prosecution could not adduce any evidence against the petitioner. The petitioner is in custody since 7/12/2022. Regarding being head to the aforementioned, I am inclined to enlarge the petitioner on bail. Accordingly, he is granted bail with all the conditions. Yes.
Okay.
Next.
74.
74.
My lord, finally taken up next week.
What is this matter, madam?
302.
302.
My lord.
Not next week. It will go to end of November. On request, adjourn to end of November. Yes. Next.
25.
Offense under section 302 and the other offenses.
Yes.
Custody, petitioner is custody since 29th
to
29th.
Date.
29 March 2024.
24. Okay.
And in this case, my lord, petitioner name is not in FIR. Neither the informant nor the eyewitness has says about his name.
Eyewitness is there, lord.
Yes.
Sanatana Pani.
Sanatana Pani and Nakula.
Investigation is over. Charge sheet filed.
Yes, charge sheet has filed.
When?
Charge sheet more with me, CD there, not charge sheet.
Yeah, charge sheet. When charge sheet is filed?
Charge sheet filed 26/7/2024.
I know. So BC
7/2024.
I know. Petitioner is agreed by the order dated 20th April 2024, whereby his bail application has been bail plea has been rejected by the trial court. Subsequent thereto, on 26/7/2024, charge sheet in the present case has been filed. On the changing circumstances, petitioner should renew the bail plea before the court of first instance. Therefore, I am not inclined to entertain this bail application. However, liberty is granted to the petitioner to renew the bail plea before the trial court on the changing circumstances. With this observation, the petitioner is disposed of. Next.
76.
76.
76. On behalf of Mr. Dibede, I am submitting, my lord.
Yes.
The case, my lord, initially the
76, 77 CD is required.
CD 76, 77.
Let me custody 24/2, my lord.
Let the CD come. Yes.
78. Lord, say me short date.
78.
77. I am listening. 77.
I'm appealing for the informant, my lord.
77, my lord. Item is 77.
Yes.
My item is 77. 77, my lord.
77 also CD.
CDI.
Yes,
My
77
item is 77.
CD called for. 78, huh?
I'm for the informant. 78.
78
Informant. I'm the
informant. Offense?
offense, my lord, 376, 6 POCSO, my lords.
Not interested. None appears for the petitioner. So appears for opposite party number 2. In the interest of justice, urgent November last. Yes.
29.
May I appeal, lordship?
Yes, sir.
Petitioner is in custody, lordship. 23/3/2024, lordship.
23/3/2024,
lordship.
24.
Initially, FIR was related under section 363, lordship.
Yes.
Thereafter, charge sheet filed under section, lordship 376 to
376 3 Lordship.
Go ahead. 154 statement was called for.
Notice issued.
Lordship, notice gone.
Service complete.
Lordship, gone, Lordship. Notice gone. Call for the statement of victim, Lordship. Last occasion.
Service, let us see the service.
Also.
Not
sufficient. Neither it is notice.
Recused file.
Notice gone.
Notice gone.
Awaiting.
Awaiting notice on opposite party number 2. Please the matter after 2 weeks. Yes, next.
Date.
80. Next.
80.
My lord. Petitioner is in custody since 28/10/23, my lord.
28/10
was examined by the learned court below on 15/3/24, my lord. And her statement, my lord. She has stated, I had started loving the accused while I was studying in class 8. In the month of 2023, my family members came to know about love relationship with the accused. There is no dispute between the two families regarding our love relationship. In para 18, my lord, it has stated, I have stated before the police that my parents had scolded me after coming to know our love relationship on 25/9/23. I talked with the accused and we decided to leave the house. It is a fact that I have stated before the police, I and the accused had got married at a Sibo temple, that we are living as husband and wife. It is a fact that I have stated before the police, I wanted to stay with the accused. And also stated on 27/10/2023, the accused was arrested. It is a fact that I had written letter to the Khajuripada police station, therein that accused had no fault in the entire incident. And I had asked him to take me away.
No,
take me away.
She was earlier arrested. My boy was earlier arrested.
No, after return from
They went
Hyderabad.
in,
No, he is in custody since 28/10/2024.
Yes.
Isn't it?
20, yes, my lord.
28
10.
10/2024.
20,
You said 23, she has written a letter. What is that?
23 is arrested. In his examination, my victim was examined, my lord, before the learned court below.
You read the last portion, you read it. I gave a letter to.
On 27/10/23, the accused was arrested. It is a fact that I had written the letter to the Khajuripada police station.
In which case he was arrested?
My lord.
In which case he was arrested?
In this case, my lord.
Earlier he was arrested.
No.
The petitioner was arrested. And the victim stated he has no fault.
I know, then he was let up.
My lord, no.
You are not able to follow what I am asking you. You say that he is in custody since 28th October 2024.
Yes, ma'am.
But in the same time, the girl says that she was taken into custody in 2023.
27/10/23. She was
Yes.
taken to custody, my lord.
Then he was on bail thereafter.
Thereafter, no. He is in custody.
When? From when?
28/10/23.
He says 28/10/2024.
That's wrong.
24 hasn't come. That's what I thought.
23, my lord.
Yes. Okay. She has written a letter to the
Yes,
IO.
yes, sir.
Leave him.
Yes, ma'am.
What happened thereafter?
Thereafter, my lord.
This is your 164 statement or evidence?
Evidence, my lord.
Then what is there? There is nothing I am granting. Right. Petition is in custody and so on so forth. Irrigation against the petitioner is. The victim in the present case has already been examined. She in her testimony has being PW2 has stated that read it out once again. Stated that give that portion. I'll reproduce. Reproduce that one. Reproduce. Okay. Reproduce. Regard being head to the nature of allegation and period of custody, and the fact that the victim has already been examined, she has virtually not supported the prosecution case. I am inclined to enlarge the petition on bail. Accordingly, the petitioner is granted bail. Okay. Next, he reproduce the entire part. Huh? Okay. Okay. Next. How many matter remain? And see, all the bail application, remaining bail application will be rolled up over to tomorrow. Let it be tomorrow.
Yes.
Because it's already 4 o'clock.
Yes. Yes.
Now I am not able to understand 24, 23. Now I'm 94?
97.
Want to withdraw?
Withdraw.
Withdraw. 94. 4 o'clock, one matter is there. He is 780. Yes, Mr. Pradhan.
130.
Regular.
No. Today's supplementary list.
It will be rolled over to tomorrow. All the matters. Earlier tomorrow, no problem.
My lord, this is very small case, my lord.
Item?
Item 124.
124. Who is there the other side? Other side is there or not? Just see.
No, government is there. State is.
Other side is not there, then is 124.
Yes, my lord.
Yes.
My lord, this is an order passed by JMFC directing that FIR should be registered under the provisions of Environment Protection Act, AR Act and Water Act. And my case is, my lord, that this procedure is barred by the specific provisions in the respective acts, my lord. This is barred by
This you moved application for discharge.
482, my lord.
For
I have
passing.
filed 482, my lord.
Okay.
And my principal ground is that this proceeding is barred by Section 19 of EP Act, Section 43 of Air Act and 49 of the Water Act.
Okay.
And my lord has recorded all this in while issuing the notice, my lord. May I invite my lord's notice to page 71, Annexure 5, the order passed by the JMFC, my lord.
Okay, on 1/3/2024.
Yes, my lord. 16 February 2024.
16 February.
Page 71, Annexure 5. It starts from page 70, Annexure 5. I am referring to the portion on 71, my lord. This
71.
Yeah,
Yes.
7. Annexure 5, my lord.
Yes, I am there.
16 February, date is given corner left hand side.
Yes,
my lord.
16 February 24.
Yes. This order arises out of petition under 156 CRPC filed by complainant, heard. Peruse the complaint petition. On perusal of the same, it is found that complainant has set law in motion with a view to make action against accused person for commission of offence. Kindly mark Section 21-24 of Environment Protection Act, 21-31 of the Air Act and 25-33 of the Water Act.
Yes.
The complainant has also mentioned the complaint petition that he has given written report to IIC and what police has refused to take on so and so. Then he has also given to SDPO and then he has also given to SP, my lord.
Yes.
And then middle of the page, perusal of complaint reveals that forwarding of his complaint petition to police investigation under so and so is conducive to justice. Keeping in view of the decision of the Honorable Court in Priyanka Srivastava and other versus State of Uttar Pradesh so and so, and having regard to nature of this allegation, this court thinks appropriate that there should be an investigation by police in the interest of justice. Hence, the petition is allowed. Send the original complaint to the IIC so and so with direction to register FIR and take steps for investigation and report the compliance. My lord, I am saying
You are
this
challenging this
procedure,
order.
yes, this procedure is specifically barred by Section 19 of the EP Act. Can you give the EP Act? My lord, I have also made one small, because I appreciate my lord is sitting at. So I made a small note of not more than 2.5 pages.
EP Act.
Giving details.
Read-
Kindly give EP
read-
Act Section 19, my lord.
Yes, cognizance. Yes. No courts are taken.
No court shall take cognizance of any offence under this act except on complaint made by central government or authority or officer authorized in this behalf by that government or by a person who has given notice of not less than so and so in manner prescribed in the alleged offence, and this intention to make
No, this is
complaint central.
Environment Protection Act.
Environment Protection Act. Similar provisions are, my lord, may mark
You have to show me in the air, water and
yes.
yeah.
My lord, may come to Air Act Section 43. Same provision is there. No court shall take cognizance.
60 days again.
Same.
Yes.
Air Act.
Air Act section.
Air Act 43, my lord.
Air Act 43.
And Water Act 49. My lord is having, or I
Yes,
can hand over
yes.
the.
Direct 43.
Yes.
This is also
Same provisions are there in all three.
60 days.
Yes.
60 days provision. All 60
Yes.
days provision.
Yes. So admittedly, this procedure has not been followed. Cognizance are barred. I have made compilation.
Violation, see, violation of water and air act and all, these are the continuing offences.
Lord, maybe
It is
continuing.
not an
offense.
isolated one offence.
Maybe continuing offense, but a special statute provides a special procedure for that. And for that, there is an agency, that is Pollution Control Board, which can initiate the criminal proceedings, my lord, not the individuals, my lord. If individuals are allowed like this, then there will be chaos. And that is why.
Where is the bar you show me in the act?
Yes,
that
my lord.
individual can't.
Yes, my lord, that is what I am saying, section 90.
So far as the limitation part is concerned,
I'm not on limitation. I'm sorry, my lord. I am not on limitation. I am on the point that the complaint can be filed only by the person who is following section 19 of the EP Act and the other acts, my lord. Section 19
it says any person who has
authorized
given
by-
notice, not less than 60 days. Notice has to be given by.
Notice has to be given to the central government in a prescribed manner. On that notice, my lord, the central government can file the complaint, but not individual can go and file FIR, my lord. This is my first point. That this procedure which is adopted by the magistrate is duly barred by the special statutes, and I am carrying the compilation of judgments, all the high courts followed the Supreme Court and quashed similar proceedings, my lord. I am relying specifically on Punjab Haryana High Court and the Bombay High Court. I will show later on, my lord. Then, my lord,
those cases, it is 200 complaint or 156.3 complaint?
Same 156.3 complaint, my lord.
Yes.
That first one is directly same. Second was rejected by magistrate and High Court affirmed it. So I'll come to judgment side. One more provision, my lord. Section 24 is also important.
24
of the EP Act.
EP Act.
Section 24 says that provisions of this Act and rules, my lord, is there?
Yes, EP Act.
Provisions
20.
of this Act
Yes.
and rules and orders made thereunder shall have effect, notwithstanding anything inconsistent therewith contained in any other law for time being in force. So this Act prevails, and the procedure given in this Act
These
prevails.
are the
Yes.
special statute prevails
Yes,
upon the general law.
and corresponding provision is there in section 4 of the CRPC, which says subject to a special laws, trials and investigation can be done in CRPC. So a special law also prevails as per section 4(2) of the CRPC law. So this is my first
Code into itself.
Yes.
These are the code.
So my first proposition is that this order to register FIR is barred by the provisions, and it is liable to be cost on this ground alone. Then my second proposition is that the complainant has not made the company as accused. Only individual, that is CEO of the company, has been made accused. And on that ground also, the Supreme Court and the High Court have said that unless you make the company
cannot
accused,
hold any water, because now it is a 156.3 stage. After investigation, police can implicate the company also.
but in one,
How do you know?
No, but in complaint cases, the court has quashed
Isn't it
that
barred?
also.
In
For
complaint case, you suppose any
Yes, yes, it
not
is
made,
barred.
in 156.3 converted to FIR, nobody else can be made accused.
The company,
There is
unless
no bar.
I'm coming to this. That's, let me give that example. In one case, there was allegation of cheating and forgery. The court held that in IPC there is no principle of vicarious liability. So offense is committed by company. Since you have not made the company offense, 482 can be exercised and complaint can be quashed. That is my second proposition. My third proposition is that I, as an individual, has been only named in the complaint without giving any indication as to how I am connected with this offense, my lord. And for that, my lord, may I show the complaint, that is Annexure 4. Annexure 4, starting at page 66.
Yes.
My lord may record and note the name of the accused. That is Sri Sunil Gupta, CEO of so-and-so, and one executive officer of Jharsuguda municipality only.
Was Manoj Kumar Tandy.
Yeah, he is government officer, my lord. So apart from this, there is no accused, my lord. And if my lord scan through the complaint, there is no indication, allegation, anything except saying that I am CEO of this company, that how I have, how and in what manner I am responsible for this offense, my lord. So on this ground also, the courts have quashed the FIRs and complaints.
Para 3 it says.
Para 3, my lord, he says that complainant or inquiry come to know that so and so illegally and authorizedly constructed so and so. Well, it is constructed by company. It is not by individual.
No,
He is saying that.
allegation is individual allegation.
So he is making individual as if I have done, my lord. And my lord, it is undisputed fact that the construction was done in 2012-13, and I joined.
What construction you have made?
I have prepared colonies for my employees, my lord, in that colony, residential township, my lord, in Jharsuguda.
Without clearance, environment.
No, he is saying without clearance, but my case on fact is that I have all the clearances. I'm not going in fact because these are factual issues and my lord will not look into 482.
It needs to be inquired into.
Yes. So that's why I'm saying on the face of it, this complaint cannot be sustained, my lord, and it has to be quashed. And one undisputed fact, my lord, that I joined as this person joined as CEO only in January 2022, after almost 10 years of the construction is over. So on all these grounds, my lord,
but see, the impugn order only says, I think it is appropriate that there should be an investigation by the police in the interest of justice.
but police cannot investigate in view of the bar created by EP Act and Water Act, my lord, because there is one landmark judgment of Justice Sinha which I have included in my complaint. CBI registered a case in FIR in TOHO Act, that is Transportation of Human Organs Act, and CBI wanted to investigate and file a charge sheet. Justice Sinha said no. CBI, even if you are authorized, you cannot adopt this procedure because a special provision says only authorized person can file complaint, and only that complaint can be taken further, not use FIR and registration of and charge sheet and all that. I'll show that judgment, my lord, for my last this thing. So let me give a summary of my complaint, my lord. It is barred by a special act. No cognizance can be taken. It is also that he is trying to make me vicariously liable for the company, but company is not. There is no allegation against company, and company is not made party. Third, that in any case, I joined only recently, my lord. So I was not relevant person even connected to this company at the relevant point of time. And then, my lord, there is no allegation at all. So let me give this compilation, my lord, and I will not read anything apart from. There is
highlight that those persons.
I have given in the index itself.
Have you given to the other side?
I have given summary in the index.
You are appealing for?
I am.
State also there, my lord.
State.
I have sufficient copies, my lord. And this is, my lord, directly on my case, my lord. In this case, my lord may see first 482 petition, first para.
Yes.
This is Ravi Sankar Gupta versus first case, my lord, in my compilation.
Yes.
Ravi Sankar Gupta versus State of Haryana, Punjab and Haryana by Punjab Haryana High Court, my lord. This is directly on the fact, so I am reading few paragraphs. Petition has been filed under 482, criminal seeking causing of FIR under so and Water Act and Air Prevention Act, my lord. And this case, this party has broken the seal put by the Pollution Control Board, and FIR was filed. That, my lord, will find the fact in para 2, end of this, my lord, para 2, Mr. 1K Nagpal, who was a private individual. I am skipping the contention, my lord, may come to para 4. Learned State Council submits that investigating agency has already concluded investigation and filed final report, and petitioner can raise all pleas taken in the present case at the time of framing of the charge. Then observations, my lord.
Yes, madam, do you have followed what?
Yes.
For some time to find.
No, I'll definitely give. But what he's saying, the real issue is what you have done is you first you gave a complaint under 154 CRPC. It was not accepted. The police didn't take on it. Then you resort to 155 by giving it to the senior officer. Once you failed there also, the senior officer also didn't take any action. Thereafter, you resorted to 156(3). And the court has taken cognizance of 156(3). Now, FIR is directed to be registered and investigation. So what you have followed? You have followed CRPC 154 onwards. And what will be the conclusion? 173. Police will file 173. This procedure you have adopted. But unfortunately, these are the offences under the special statute. And there is a clear bar that you have to proceed in accordance with these provisions. So since you have adopted CRPC procedure, which is barred under these provisions, these special provision, therefore he is challenging. This is the first ground. Second ground is who can be a complainant. The procedure is established under this special act itself. You have to give a complaint to the competent authority. Competent authority will prosecute through a complaint procedure, not through a procedure like FIR and all, warrant trial. So therefore, there also you are having a problem. This is second point. Third point, what he is trying to say is the reading of the complaint indicates that there is no specific allegation against this gentleman, the CEO of the company. And the company has not been made as a party. So therefore, this complaint on merit also is not sustainable. Fourth one, what he is trying to say is that when the offence alleged to have taken place, on that day, he was nowhere in the picture. He joined recently. These are the 4 points he is highlighting. And for first 2 points, he has circulated a compilation.
Compilation is all points.
I think these 4 points is enough. If they succeed in these 4 points, you are out. If they don't succeed, then further point you will. This is what is the long and short of the issues. Okay. Parthead, and you read it and answer it. Okay.
Intervention, my lord.
You
One small prayer, my lord.
You are the intervener in this.
No, my lord. I am on item number 117.
Oh, let me conclude this part. Then I will see. And Parthead and keep it date. When how much time will you?
2 weeks.
2 weeks. 2 weeks after Rakho. But read it. Huh?
My lord may indicate a date.
Date will be indicated. Don't worry. Date will be indicated at 3 o'clock.
30th.
3 o'clock.
My lord,
You also just see. These are the legal issues. You have to answer this legally. I have formulated.
I know to always through the Tahsildar it should go, but they have directly came here.
I formulated
Yes,
the issues.
yes.
These are first 2 issues are legal issues. Second is on merits.
Yes.
Merits we will look into. If the legal issues is succeed, why should you get
Merit, I am not pressing, my lord, because that my lord
merit is
is a
generally
tribal issue and all.
investigation is going on. He will raise all these issues.
State pollution will also directly only will give to the Tahsildar through them only agency only they are doing those things.
But whatever, you answer that.
Yes.
Whether you
But
can
in all
get
those
through.
even serious cases, NDPS, transfer of organ act and all, the court said you have to follow the special act, not the CRP.
If there is a specific,
So, yes.
specific procedure established
Yes.
under the code itself,
Yes.
the special code, then you have to follow that procedure. You can't adopt another procedure. That's the grievance. And unfortunately, you followed direct 154, 155, 156.
It will come, lots of, it will come always. After that 25 to 30, if suppose pollution of water or air, if that will not followed properly, then only CRPC will arise. That is there.
Whatever answer you have,
Yes.
you may have a right
Yes,
answer also.
yes.
Yes.
Any other day, my lord, because 30th there is some part of matter.
Any other day.
17, is it possible? Let's see that.
17, no. 2 weeks age it is just.
Any other day.
Third.
Third we can do.
Third.
Deeply.
Third.
My lord, may I mention item 129 or something?
It is there on the board.
Press admission. It is not reaching. So for press admission on it.
And today in the morning hour, lot of adjournment prayer and all.
It will take only 2 minutes.
Let it be there tomorrow. Tomorrow I'll take
My
it.
lords,
Item 129.
I may be
Tomorrow
part.
I'll take it up.
My
Definitely.
lords, one small request, my lords.
Yes.
Tomorrow post lunch, can I be accommodated? I have some
Yes,
personal
yes,
difficulties. Great.
My lord, item 99. The matter may kindly be taken up 17th or 18th, my lord.
Don't fix the date.
No, 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 I just pray, my lord.
What is that?
My lord,
Admission matter. We'll see.
My lord.
We'll give a date according.
Lordship's item
117 only he's saying or something. 117?
117, my lord.
He is appearing in 117. You are also appearing? Petitioner, you are intervener.
No, my lord.
Who are
I
you?
am the opposite party.
Oh.
pardon, my lord, item 99.
So first you decide which matter you are. I'm not sure about which matter you are.
I am the petitioner, my lord. I am the petitioner.
Which matter?
Item number 117.
My lord, item 99.
Very interesting.
Grateful.
He will give a date. Just
Yes,
give
yes.
the date. Yeah. Yes. Any other mention?
129,
My lord, item 99. The small prayer, my lord, IA 2274. Only city case number should be there 3622 instead of TR case number, my lord.
Number which item?
Item 99.
For modification, clarification.
My lord.
99 allow kordo, allow.
my lord, item 129 may retain its place.
It is written, Mr. Samantrai. It is there tomorrow.
We do apology, my lord. Item 78, my lord. Appearance no. I'm for the petition.